Hey, everybody. Welcome to a special live edition of Guns and Gadgets. Trying to get everything set up. I was a little late getting everything done because we got about 9.5, 10 inches of snow out there right now, and it's still coming down. So if you hear rumbling in the background, my driveway is currently being plowed, and it's like 3.5 feet outside this window right here. So I apologize if you hear it, but it's New England. It's hopefully my last winter ever because I hate it. I am going to see if I can get this working here. Looking at the chat real quick. Thank you, everybody, for being here. If you could, real quick, before the Supreme Court actually goes live, if you could help the stream out by liking and sharing this. And if you haven't already, please subscribe because, the subject that they're taking up right now is not going to be very popular for big tech, so they're probably not going to let a lot of people see it natively. And for those who are curious, there are actually 4 different cases that are being presented or challenged today. It's actually down to 2 because 2 of them have been enjoined in each scenario. They've been consolidated. So I'll give you the names of the cases for your own reference. The first hearing is going to be these 2 consolidated cases. The first one is the National Federation of Independent Businesses et al. Versus the Department of Labor and OSHA. And the second part of this first hearing is going to be Ohio et al. There's other states involved versus the Department of Labor and OSHA. So that is going to be, it says it's consolidated, 1 hour for argument. And the way that they have it broken down on paper, and they're typically pretty good at staying to this, is the attorneys for the National Federation of Independent Businesses have 15 minutes. The Department of Labor will have 30 minutes, and then the attorneys for Ohio will have 15 minutes. So basically each part has 15 minutes for each lawsuit. So there's technically 2 lawsuits joined in the first hearing. DOL will have 15 minutes to address the Ohio section and 15 minutes to address the National Federation of Independent Businesses section. There goes my plow guy. The second hearing will come right after that, and it's again 2 cases that join together. I'm watching the clock close here because they just jump on. They don't give you any warning. It's going to be Joseph R. Biden Jr., President of the United States et al. Versus Missouri et al. There's other states as well. And the second case that has been consolidated with it is Xavier Becerra, former governor of California, now Secretary of Health and Human Services et al. Versus Louisiana et al. Again, same thing applies. The attorneys have 15 minutes on each side, and then the principal deputy solicitor general will be arguing on behalf of the president. So we'll hear what kind of unconstitutional BS that the president is going to try to push for these vaccine mandates. And he'll have 30 minutes, again, 15 minutes for each of these technical lawsuits. They're technically different lawsuits, but they've been enjoined. So I want to thank everybody for taking time out of your day. It's Friday. I get it. People are working and stuff. The Supreme Court doesn't typically take up stuff like this, and I'm glad that they are. And to a few people that have reached out who are asking why I'm covering this, because it has nothing to do with the Second Amendment. I will say that it's always freedom first, and what we are about to witness here as a group together is history in the making. This is the Supreme Court taking up an issue of a tyrannical mandate. I want to also, before I forget, tell you all that I highly, highly suggest and recommend you go on Spotify. It's free. It's an app. It's on every Apple TV. It's on everything. And it's typically for music streaming, but there's also podcasts on there. Go on the Joe Rogan Experience. Whether you like Joe Rogan as an individual or not, don't care. But these 2 interviews you really should listen to. If you're interested in these cases and these mandates, if they affect you, whether you're for them or against them, you all should listen to these 2 people that he interviewed on separate occasions who are definitely in the know and tell you more truth than you're getting anywhere else. Dr. Peter McCullough and Dr. Robert Malone. Please watch those. I know that as long as you go in with an open mind, you will come out much more educated in what's going on. And the reason things are being pushed the way they are will become a little more clearer to you. So again, thank you all for being here. While the court is in session, I'm not going to talk because I want to hear them, and I know people also want to hear them. So I will keep my commentary to a minimum while they are talking. This is what our screen is going to look like right there while they are talking. Again, the Supreme Court doesn't have or doesn't allow their courtroom yet, and they're still closed for COVID. So yeah, with that, I will make sure we're good to go. It looks like everything is functioning correctly. If there's any issues on your end, hearing it audio-wise or whatever, especially once I tap into the Supreme Court's audio, please let me know and I'll do my best. And I threw on headphones so we don't get the echoing and the squealing and stuff like that. I hate wearing these, but it is what it is. And I'll do what I can to make this good for everybody. Now, I also want to say real quick, we have about 2 minutes. Supreme Court is the judicial system. Remember, we have three branches of government, checks and balances. The Supreme Court right now has a really good chance, opportunity to right a wrong. And whether you're for or against the vaccine, I'm not anti-vax at all. If you want to get them, you think it's good for you, fine. I just know it's good for me, especially after listening to the doctors who are more informed in this than everybody in the media. The Supreme Court really has a good opportunity here to kind of reestablish some checks and balances. That's why I am really, really interested in this. Thank you. Appreciate it. No, I don't. I know she had the coof right before her Senate hearings. Again, whether it's an individual thing, we're all Americans. I'm not going to jump on people if they want to wear a mask. I'm not going to jump on people if they don't. I prefer not to. I've had the COVID. I've come out of it on my own. And based off these two doctors who know more than every channel, every media conglomerate, I am better off now than I was before. And taking something will make me more susceptible. And don't take my word for it. Please listen to the doctors on the Joe Rogan interviews. And here we go. I'm going to switch over. Thank you all for being here. Okay, nothing yet from them, it seems. So let me double check. I'm going to take these off. Sometimes it doesn't operate as smooth as we hope. Yep, nothing yet from them. So we're about 30 seconds away from my calculations. And I'll try these again just to keep everything copacetic. Well, as soon as they start going, guys, I will cease the yapping. But please share this if you could, and like the video. Helps more people see it in the algorithm. And if you don't mind, please subscribe to the channel and check your subscriptions if you haven't already, because the game's been going on, and I'd appreciate it. Yeah. Yeah, gun doctor. You got that right, man. They typically jump right into it though, which is why I'm trying to stay on it. So yeah, there we go. Here we go. Stand by, y'all. They had a hiccup. Yep, I know you can't hear it. Hold, give me 1 minute. Stand by, y'all. Let me reload this page. There we go.
So the factors you'd want to consider are what are the risks, and not only what are the risks.
McCulloch versus Mayor, Chief Justice Marshall. necessary or not necessarily really necessary. You need more than to say, oh, a lot of bad things could happen to interpret what that means. Is it restrictive? Is it very firm? Is it super necessary? And if it is, why?
Justice Thomas, the reason why it would be something approaching the indispensable or essential definition of necessary here is there's a very key intra-statutory textual clue. The emergency power must be necessary. The regular power that OSHA wields has to be reasonably necessary or appropriate.
So when do we determine that? Suppose you argue also this is the vaccine's been around quite some time. COVID has been around even longer. So the government could have had a notice and comment. So if it's susceptible to notice and comment, then how do you analyze it in that context? You can't just say, well, it's emergency, therefore it has to be absolutely necessary. It would seem that would undermine your definition or your notion of necessary.
Well, I think Judge Larson for the Sixth Circuit was absolutely correct in saying that just because something's temporary doesn't mean that there could somehow be more power. And what this court has said is this emergency power is narrowly circumscribed. And regardless of wherever the line would be drawn, I think this ETS is far past it. And I think the federal government has some serious line drawing problems of its own. I believe OSHA, under the theory that's been advanced, could have shut down and had a national work lockdown at the beginning of the pandemic. I would submit that this court and industrial union in saying that OSHA had no clear mandate in the act to have that wide of power over the American industry is also a factor that would go into this court construing what necessary means.
So the fact that it is temporary, that it's emergency sort of ups the ante, that necessary has to be more restricted.
Yes, because of plain text, the comparison within the OSHA Act, also statutory context.
Because Mr. Keller, I don't understand the point. Whatever necessary means, whether it's a necessary and proper or whether it's something more than that, why isn't this necessary to evade a grave risk? This is a pandemic in which nearly 1 million people have died. It is by far the greatest public health danger that this country has faced in the last century. More and more people are dying every day. More and more people are getting sick every day. I don't mean to be dramatic here. I'm just sort of stating facts. And this is the policy that is most geared to stopping all this. There's nothing else that will perform that function better than incentivizing people strongly to vaccinate themselves. So, whatever necessary means, whatever grave means, why isn't this necessary and grave?
Because Justice Kagan, the standard for what would be necessary for this extraordinary use of emergency power is not what is the best way of accomplishing.
It's an extraordinary use of emergency power occurring in an extraordinary circumstance, a circumstance that this country has never faced before.
What OSHA needed to do here, though, and we do not contest that COVID is a grave danger, but when the power for it to be necessary, for instance, the Third Circuit said in wielding what is supposed to be a delicately exercised extraordinary power, the agency has to consider and explain alternatives. The agency here complained that its non-mandatory guidance wasn't being followed. And then instead of saying that maybe some of those guidances could have been made mandatory, it jumped immediately to a vaccine or testing mandate. Moreover, OSHA typically...
Mr. Carter, I guess I just don't see this as a situation, a typical arbitrary, capricious situation where we say, oh, you didn't consider an alternative carefully enough. We all know what the best policy is. I mean, by this point, 2 years later, we know that the best way to prevent spread is for people to get vaccinated, and to prevent dangerous illness and death is for people to get vaccinated. That is by far the best. The second best is to wear masks. So this is a policy that basically says we are still confronting thousands of people dying every time we look around. And so we're going to put into place the policy that we know works best, which is to strongly incentivize vaccination and to insist that unvaccinated people will wear masks and test. I mean, that's just like Why isn't that necessary? What else should be done? It's obviously the policy that's geared to preventing most sickness and death, and the agency has done everything but stand on its head to show quite clearly that no other policy will prevent sickness and death to anywhere like the degree this one will.
Justice Kagan, first of all, states could have policies like this. Private businesses could have policies like this. And even OSHA in its June healthcare COVID ETS, and that was only for healthcare workers, did not mandate vaccines. Instead, what it did there, similarly to how OSHA proceeds in many contexts, is it says, employers, give us a plan, and then if there are heightened needs in particular workplaces, then additional measures can be put into place. But this is covering economy-wide, all industries.
Well, that's
84
That's
million
one of that's one of your main objections, that this is not a workplace issue. It's an out in the world issue. Is that right?
That's right, Mr. Chief Justice.
Well, how focused on the workplace does something have to be before you will say that OSHA can regulate it? And think, for example, of an assembly line. Workers sitting next to each other for a significant length of time, working together in close contact. That presents a different kind of risk than is typical in the outside world. So could OSHA say that for businesses with assembly lines, the workers must be vaccinated?
No, not vaccinated. OSHA, though, could potentially, going by industry or workplace by workplace, have measures such as what some of their guidance have suggested, like potentially barriers. But I think all of this would be.
Well, but those are sort of, as Justice Kagan has been discussing, those are sort of, not as good. And why wouldn't OSHA have the authority to do the best approach possible to address what I guess you agree is a special workplace problem?
Well, Mr. Chief Justice, I don't think the standard here can be the best, because if it was the best, then that would mean that OSHA could ban all people from coming into the workplace. I think that is a power that Congress, when it
Well, so the agency is acting, less aggressively than it might otherwise do, but in an effective way to address the problem.
But as soon as we get to the point where we're talking about a less aggressive way, there are other alternatives. There could have been plans. There could have been the non-mandatory guidance that was then put into place. Jumping to a vaccine or testing mandate when OSHA has never exercised that.
Well, there is some pressing urgency to addressing the problem, and having them sit down and say, okay, what else could we do? We have to have notice and comment, which I guess, are you insisting that be part of the process?
In this situation, yes. You have the Postal Service and Amtrak saying many employees will quit. Here, there are reports.
Well, just because the post office can't do it efficiently doesn't mean that the private industry can't.
But I think what this shows is workplaces are different. And instead of doing an economy-wide vaccine or testing mandate for all purposes, OSHA needed to at least consider, as it identified, there are certain instances where healthcare workers and otherwise, in those industries where there's a heightened risk, that's where there's a workplace occupation.
I want to ask a provisional question. Are you still really asking this court now, today? I mean, I assume you have good arguments in your brief, and so does the government. So I'll assume for the sake of argument that they're both fairly good arguments, okay?
Thank you.
Right. Now, that's an assumption. Right. But make that assumption. Are you still asking us to issue a stay and stop this from taking effect? Like issue a stay today or tomorrow or Sunday or Monday or Tuesday? I mean, the reason I ask that is there are several elements. We have some discretion there. And it was brought up. I mean, there are 750,000 new cases yesterday. New cases, nearly 750,000, 700 and some odd thousand, okay? That's 10 times as many as when OSHA put this rule in. The hospitals are yesterday, full, almost to the point of the maximum they've ever been in this disease.
No, they're not.
And you heard references, studies. I mean, they vary, but some of them say that the hospitalization is 90% or maybe 60% or maybe 80%, but a big percent filled up yesterday or the day before with people who are not vaccinated. Okay? So that's what we're talking about now. And think of the stay requirements. It's both the balance of harms, it's also public interest. Can you ask us, or is that what you're doing now, to say it's in the public interest in this situation to stop this vaccination rule with nearly 1 million people? Let me not exaggerate, nearly 750,000 people. New cases every day? I mean, to me, I would find that unbelievable.
Justice Breyer, we are asking for a stay before enforcement takes effect Monday. And the reason for that is this is an unprecedented agency action.
Yeah, I know you have all good arguments that it isn't good. They have arguments that it is good. Okay, I'm asking you a different question. And the question is, how can it conceivably be in the public interest with 750,000 people yesterday, goodness knows how many today? And I don't want to repeat myself, but you have the hospitalization figures growing by factors of 10 times what it was. You have hospitalization at the record, near the record. You understand the things as well as and so I repeat my question. To me, it's unbelievable, but I want to hear what you say. How can it be in the public interest, which is a requirement? How can it be a balance of harms in this case? Assuming the arguments aren't off the wall on the government side, and believe me, they're not. Okay, that's what I want to hear the answer.
Justice Breyer, states can act, private businesses have acted on historic levels. This is going to cause a massive economic shift in the country. Billions upon billions of non-recoverable costs. Testing also is not frequently available. This is in our appendix at page 374. Among those employers who attempted to do so, only 28% are able to find adequate providers to ensure that weekly testing is available for the employees. If Congress intended to give an occupational health agency the power to mandate vaccines across the country, it needed to do so clearly. States can do it, businesses have done it and are able to do it. The question is not what is this country going to do about COVID, it's who gets to decide that.
Well, Mr. Keller, maybe it's point we can go to Justice Thomas, anything further? Justice Gorsuch.
I do have a couple of questions, Mr. Keller. First, the government says that the major questions doctrine and federalism canon, for example, don't apply to this court's consideration of this case or any other unless the statute or force is first found to be ambiguous. What's your understanding?
2 points. If you need to even reach the question of whether there's ambiguity, and we think the term necessary is clear in context and has to mean indispensable or essential, that would be a term where potentially the government in their interpretation would reach ambiguity. But regardless, the major questions doctrine is also in service of avoiding non-delegation concerns. And the non-delegation concerns that this court recognized in Industrial Union and citing
I'm sorry to interrupt you, but that wasn't quite my question. I apologize if I didn't make it clear enough. But the government says that we only consult those doctrines, the federalism canon, the major questions doctrine. I think the court understands what they are, but only consults them after finding a statutory ambiguity. Do you disagree?
I disagree in that the major questions doctrine is also a doctrine that would avoid non-delegation concerns. So even if there were a clear statutory term, non-delegation concerns and how to interpret that statute would factor in. Regardless, I think the term necessary here, there's plenty of room to implement the major questions doctrine there, in addition to all of the workplace tethered languages in the plain text and statutory context.
And then secondly, I would like to understand your argument and your colleague's argument from Ohio, I believe it is, why the court should enter a stay immediately. You asked for immediate relief. Why should the court grant immediate relief?
The short version is as soon as businesses have to put out their plans and this takes effect, workers will quit. That itself will be a permanent worker displacement that will ripple through the national economy. So we can talk about the billions in non-recoverable costs that the government even concedes, and we can talk about lost profits and lost goodwill and lost business reputation, and we can talk about the businesses that are going to be put out of business. Our appendix at pages 375 to 80 quotes many businesses saying this would be catastrophic. It would bankrupt our company. It would be the most devastating event our company has ever experienced. That's why we're here. We're asking for an extraordinary stay. We understand the gravity of the situation, But in balancing the sheer size and scope of this emergency power that is supposed to be exercised delicately and the national economic implications of this when states and businesses can and have acted, we are entitled to a stay in this posture.
Justice Alito, sorry to point out of order.
No, fine. Mr. Keller, I just want to make sure I understand what we should focus on here. Is the question whether this ETS is necessary to protect the health of the general public, or is it whether it is necessary to protect just employees, and not even all employees, but only unvaccinated employees, people who have chosen independently not to be vaccinated and do not want to be vaccinated? Is that the proper focus?
Correct, the latter, Justice Alito. As OSHA has said, the grave danger here is to the unvaccinated worker who's exposed to COVID.
Thank you.
Justice Sotomayor.
Justice Sotomayor. So I just heard somebody clear their throat. Maybe
Justice Sotomayor, the necessary analysis does have to account for alternatives.
We couldn't hear her.
Anything close to a least restrictive means analysis. What we're saying is that
that's on their end, guys. I still hear audio in the background. So either they're trying to fix it on their end or they crossed over to Sotomayor now after the fact and don't realize they don't have the main feed on.
I think even if you accept the agency's facts, they're now, as Your Honor just mentioned, CDC guidance contradicting foundational assumptions of the CTS. That's in our reply brief at page 7, and Your Honor just mentioned that. But regardless, even OSHA has said that 1% to 3% of employees will quit. That is significant. Our declarations, Appendix 308, 316.
Counsel, yes, that may be true, but we are now having deaths at an unprecedented amount.
No, we're not.
And COVID keeps people out of the workplace for extraordinary periods of time. And there have been proof in certain industries like the medical industry that when vaccines are mandated, and there's no mandate here for a vaccine, there is a masking mandate, no different than there is when we tell people that if there are sparks flying in the workplace where workers have to wear a mask. So that's no different in my mind than this. So this is not a vaccine mandate. there are costs and deaths and other things countervailing to the fact that there might be 1 to 3% of workers who leave.
And here, vaccines have been made available. I also think there's a textual clue within the OSHA Act, 29 USC 650.
You forget that there are certain states now that are stopping employers from requiring vaccines. There are certain states stopping employers from requiring masks. Why shouldn't the federal government, which it has already decided in OSHA, Congress has decided to give OSHA the power to regulate workplace safety, have a national rule that will protect workers?
Congress would have to clearly state in a statute if it wanted to give an occupational health agency the power to require employees to get certain medical treatment. It's one thing to say.
There's no requirement here. It's not a vaccine mandate. It's something totally different. And I don't know how much clearer than 651 Congress could have been. It charges OSHA with developing innovative methods, techniques, and approaches to dealing with occupational safety and health issues. I don't know how much clearer you can be if you're Congress to tell an agency in an emergency, do what's necessary. I don't think Congress can do it, do you?
If Congress was going to give an occupational health agency this type of power to essentially regulate directly the employee, rather than telling employers these are the types of things that you would want to do within your workplace, it would have had to provide that clearly. And
so what's the difference between this and telling employers where sparks are flying in the workplace, your workers have to wear a mask?
When sparks are flying in the workplace, that's presumably because there's a machine that's unique to that workplace. That is the...
Why is the human being not like a machine if it's spewing a virus, bloodborne viruses? Are you questioning Congress's power or desire that OSHA do this? It already in 1991 told OSHA to issue regulations with respect to Hep C and B.
Justice Sotomayor, I think that exactly proves our point that Congress knows how to enact a statute when it wants to give...
It didn't enact a statute. OSHA proposed regulations. It didn't act fast enough, and Congress told it to act faster. So it wasn't Congress who proposed it. It wasn't Congress who devised it. Congress gave OSHA the responsibility to do these things, and Congress was saying, get to it.
And what Congress said in there was not, you now have statutory authority to regulate all communicable diseases. It was bloodborne pathogens, and even that rule did not mandate vaccines or widespread testing.
Justice Kagan?
Part of your argument I want to come back to, because your very last sentence you said, the question is who decides? And I think that that's right. I think that that is the question. Respectfully, I think it has a different answer than the one that you give. So I'll just sort of put a different version of it to you, which is, I'm sure you're right that there are all kinds of public health and economic trade-offs that have to be made in a policy like this. All kinds of judgments on the public health side or the economic side, how those two things ought to be balanced against each other. So who decides? Should it be the agency full of expert policymakers and completely politically accountable through the president? This is not the kind of policy in which there's no political accountability. If people like this policy, they'll go to the polls and vote it that way. If people don't like it, they'll vote that way. This is a politically accountable policy. It also has the virtue of expertise. So on the one hand, the agency with their political leadership can decide, or on the other hand, courts can decide. Courts are not politically accountable. Courts have not been elected. Courts have no epidemiological expertise. Why in the world would courts decide this question?
Congress and states and governors wielding emergency power are the ones that have the power, and we acknowledge that, over vaccines. The idea that OSHA would be the agency in the federal government that's not even under the Department of Health and Human Services, that does not have expertise over communicable diseases like the FDA or CDC, maybe that would just be a very odd place for Congress to lodge such a sweeping power over the American people.
Well, OSHA has a lot of expertise about workforces and about the dangers that workforces can confront individual employees with. And I'm sure OSHA also talked to other agencies within the federal government to consider public health issues and brought that knowledge to bear as well with its knowledge of how workplaces function. And again, came out with a well-supported policy that has political leadership behind it and all the political accountability that one could wish for. And why is it that courts would displace that judgment and say it is up to us to decide about vaccination policy in the employment settings of this country?
Well, first of all, what OSHA did here was not an industry by industry analysis. I mean, the line it drew, for instance, with the 100 more employee lines, they said they were doing that because they thought these larger companies were the ones that had the administrative capacity to do it. It wasn't because they were denser working environments. You could have a company with 100 employees and every single person is working somewhere else. Even the narrow exception that they have, even they say that 9% of landscapers and 5% of highway workers are the only ones that would qualify for their exclusively working outside exemption. So even occupations in which you would think someone is almost exclusively working outside, they are still covered by this ETS. It's those types of internally inconsistent positions that aren't taking account of the full problem that could have been explained and should have been explained.
Thank you, Mr. Keller.
Justice Kavanaugh?
I want to follow up on Justice Kagan's who decides question, because I do think that gets to the heart of this. You're relying on the major questions canon and saying that when an agency wants to issue a major rule that resolves a major question, it can't rely on statutory language that is cryptic, vague, oblique, ambiguous. But the critique of that canon and the difficulty in applying it is figuring out when something is major enough. We've applied it 5 or 6 times in the last 40 years, and you know the cases, and they're important. We'll talk about them, I'm sure, as the argument goes on. But what should we look at to say this one is the kind of rule that rises to the level of the benzene rule or the tobacco rule that we found to be major? What should we look at?
So Alabama Realtors just said the sheer size and scope. Size would account for the overall economic impact. This covers 1.8 million establishments. The number of people affected would be another factor. This covers 84 million, or 2/3 of the private workforce. The amount of money, King versus Burwell said billions in costs, and here we have that even conceded by OSHA. The scope also. All of the 10 prior ETSs that OSHA has done, none of them have mandated vaccines. None of them have mandated widespread testing. Only one in June even dealt with COVID. The rest were all workplace toxins, and most of those challenges were most of those challenges were vindicated by the courts. And so the scope of what the agency has done before, in addition to widespread effects, those would be the factors that you'd analyze. Also, is this a profound and earnest debate over a question of vast political and economic significance? I don't, at this point, believe that the federal government is contesting that this absolutely satisfies that.
And one follow-up question. Suppose it is major enough, so accept that position for the sake of this question. Suppose the statutory language is general, broad, but doesn't speak specifically to the issue in question, but it is general and broad language. How do we sort out, so you don't necessarily say the language is ambiguous, but it also doesn't speak specifically to the issue. How would you suggest we sort out that kind of question? I realize you're going to say this language is different, but how would you sort out that kind of question?
You look at the plain text from Brown and Williamson. We know you'd also look at the statutory context. And I also think the statutory context here is incredibly important when you have the distinction between the emergency power and the regular power. This is the dialogue earlier with Justice Thomas about necessary versus reasonably necessary or appropriate. All of those textual clues, where powers have been lodged within the federal government, the fact that this is within the Department of Labor rather than the Department of Health and Human Services. Also King versus Burwell too on, is this the agency that has expertise over communicable diseases? No, it's not.
Do you think the agency could do this under its general power then?
No, I do not think that the agency could do an economy-wide vaccine or testing mandate across the entire economy. It has never done that even through its regular power. It didn't do that in June in an ETS targeting healthcare workers, arguably the most heightened high-risk workplace.
Thank you.
Justice Barrett?
Mr. Keller, I want to return to the discussion you were having with both the Chief Justice and Justice Kagan earlier about whether the vaccine or test requirement is necessary to address a grave danger in the workplace. I think you would be hard pressed to contest the Chief's point that there are some workplaces in which the danger to employees is different than that they face out in the world. A meatpacking plant or a healthcare, the dentist. And I think what you're saying, I think this is what you're saying, and I want to be sure that I understand it, that I'm correct. I think what you're saying is that even if there are some industries or some people who would face a grave risk, and this might be necessary to address that risk, so in other words, if OSHA had adopted a more targeted rule, you might not be contesting that, or you would not be contesting that the problem here is its scope, and that there's no differentiation between the risk faced by unvaccinated 22-year-olds and unvaccinated 60-year-olds, or industries, you were just talking about landscapers and people who work primarily outdoors, those and workers who work in an inside environment all day long. So is that the distinction that you're making? Like, they're not disputing what Justice Kagan said, that, you know, this is a grave danger and that in some circumstances this rule might be necessary, but just the scope of it makes it different.
That's right, Justice Barrett, but I just want to be very clear about this. Wherever that line is, this ETS is so far beyond that line. Congress identified and even OSHA identified, for instance, certain healthcare scenarios. For instance, if you're treating COVID patients or you're a scientist in a laboratory handling COVID samples and researching them, of course that's going to be a very different case. But here, what OSHA did was economy-wide. It said,
well, I understand that, and you're saying that that's the problem. You're not contesting that if we were talking about healthcare workers or a meatpacking plant, you're not contesting that OSHA could rely on its emergency power to impose this kind of requirement in that context.
That's right. I would still want to know what their explanation was and all the substantial evidence. But yeah, of course, that's a very different case. And I know that's always not a satisfactory answer. But here, this ETS is so far beyond healthcare workers, and what Congress identified in the rescue plan is truly high-risk workplaces.
Right. So you're saying that when we take the definition of necessary, particularly when contrasted with reasonably necessary in the general grant of authority, that it means something more, and that when we're looking at grave danger, there had to be a more targeted industry by industry analysis?
Yes.
Okay. And a follow-up, would you be here making these same arguments if this were just a masking and testing requirement and not the vaccine portion of it?
Yes, I think that mandatory testing is still a mandatory medical procedure. OSHA has never, even in a regular rule, done a blanket widespread testing regime over 84 million Americans.
What if it was just masking?
I don't think OSHA has the ability to set by emergency rule nationwide COVID policy. The more that we back out of this and the more we say, well, if it's not an emergency rule, if it's targeted to a particular workplace, I think there can be debates about that. But as long as they're trying to set a blanket-wide, economy-wide policy by an emergency rule, OSHA does not have that power.
Thank you.
Thank you, counsel. Mr. Flowers, I don't quite know where to look, but are you still on the line?
I am, Mr. Chief Justice.
Thank you. You may proceed.
Mr. Chief Justice, and may it please the court, OSHA typically identifies a workplace danger and then regulates it. But here, the president decided to regulate a danger and then told OSHA to find a work-related basis for doing so. This resulted in the vaccine mandate, a blunderbuss rule nationwide in scope that requires the same thing of all covered employers, regardless of the other steps they've taken to protect employees, regardless of the nature of their workplaces, regardless of their employees' risk factors, and regardless of local conditions, state and local officials are far better positioned to understand and accommodate. So sweeping a rule is not necessary to protect employees from a grave danger as the emergency provision requires. And I want to be clear, the states share OSHA's desire to bring this pandemic to a close, but the agency cannot pursue that laudable goal unlawfully. I welcome your questions.
So you're saying, Mr. Flowers, that the first step in OSHA's regulation is to identify the workforce, the problem in that workforce, and then regulate that?
That is typically how OSHA proceeds. I don't know if there's a requirement that says they must do that, but I think part of the problems we're seeing with this rule is it's not truly intended to regulate a workplace danger. It's a danger that we all face simply as a matter of waking up in the morning.
I'm sorry to interrupt you, but the other part of my question is, can a danger be so acute in the society that it is brought into the workforce and could hence be regulated by its mere presence there and by the fact that it is so acute?
I think what they need, let me answer this in two steps. I can first define what we mean by work-related danger and then talk about how that applies here. I think that'll get to your question. So in terms of what we mean by work-related danger, I think one way to think about that is, has the employer done or failed to do something that creates the risk the employee faces? And then the problem with applying that here is if you look at their own explanation for what the risk is, this is the 61,411 of the Federal Register. They say the reason there's a risk in every workplace is you come into contact with people at the workplace. When you define the risk that broadly, that is not something that's arising out of the workplace. That's a risk we face when we wake up, when we're with our families, when we stop to get coffee on the way to work, at work, when we go to lunch, and in the evening if we go to a sporting event or a concert. So this kind of goes to Justice Barrett's question, I believe, that if they were to focus on a risk arising out of a particular aspect of the workplace that creates a risk of a different nature, like being packed closely together in a meatpacking plant, that could fairly be described as a work-related danger.
Mr. Flowers, sorry to interrupt. Do you know of any workplaces that have not fundamentally transformed themselves in the last 2 years? I mean, maybe like landscapers, they work outside. But I mean, this idea that there are only a few select workplaces that are affected by COVID, I would have thought every workplace has been affected by COVID. Every workplace sent their workers home. Every workplace had to make adjustments to the way they do their business. I'm trying to figure out like why this is a blunderbuss approach when everybody knows from living their normal lives that every workplace has been affected by this, save for, a few here and there.
So the way I would answer that is to say just about every workplace has been affected, but that doesn't mean the work is arising from the workplace. To take another example, if you look at terrorism, there's some risks of terrorism that we face when we wake up in the morning. We face it at home, in public, and at work. And we adjusted to that after 9/11. You see something, say something, ideas like that. Now, the fact that you face that risk when you go to work doesn't make it a workplace risk. It means it's an ever.
Well, why not? I mean, this is the combination of lots of people all going in to one indoor space and having to deal with each other for 8 hours, 10 hours, however many hours a day. In those settings, the combination of the environment and the people that are in that environment create a risk, I would think. I mean, tell me if I'm wrong about this. I would think the workplace risk is about the greatest, least controllable risk with respect to COVID that any person has. Everything else a person can control. You can go to the baseball game or not go to the baseball game. You can decide who to go to the baseball game with. But you can't do any of that in workplaces. You have to be there. You have to be there for 8 hours a day. You have to be there in the exact environment that the workplace is set up with. And you have to be there with a bunch of people you don't know and who might be completely irresponsible. Where else do people have a greater risk than at the workplace?
Well, I think one thing with their families that they have to spend even more time with, especially if they have children going to school and things of that nature. But in response to does the risk, of course the risk arises at the workplace, but it's important to focus on the risk they're talking about. They're not talking about jobs where people do congregate in settings like that changes the nature of the risk. They say every single workplace where people come inside for even a little bit is covered. And so they've defined the risk can mean simple human contact. And it could be no more contact than you have at the grocery store, or when you drop your kids off at school, or when you go to a friend's house.
Well, Mr.
And that's
Chairman,
the problem. We're not
in fact, what this rule does is it says we're not going to regulate some people who work outdoors, forget about it. People who work alone, we don't have to worry about them. But people who work in the way that lots and lots and lots of people work, which is surrounded by other people in indoor spaces, without their own offices, with cubicles or in other mass settings, that's where the greatest risk is. Not just that's where the risk of ordinary life is. That is, in fact, where the greatest risk is.
And if they had taken that approach, they would have a much better argument, but they don't, because there are many jobs here, including, for example, landscapers who may spend a little bit of time inside, 5 minutes a day to get the keys or punch their time card.
Is this right? What this says, my law clerks have been busy beavers on this case, I promise you. And what they have on this issue is that there are exceptions here. There aren't exceptions business by business, but there are exceptions, those who work from home, alone, or substantially outdoors, or those who can show that their conditions, practices, means, methods, operations, or processes make their workplaces as safe and healthful as the ETS can obtain a variance. Okay, so they did make some distinctions, not industry by industry. But my question really is, what I'd like to turn this to, is stay. You heard what I asked. I mean, 750 million new cases yesterday, or close to that, is a lot. I don't mean to be facetious, but that's why I said I would find it, unbelievable that it could be in the public interest to suddenly stop these vaccinations. And the only answer that was given was a lot of people will quit. Well, OSHA considered that. My wonderful law clerk has 61,475, 63,422, 61,466, 61,474, 475. Those are pages. I don't think you should read all 61,000, but nonetheless, there are at least 5 or 10 pages where they went into this. And they said, in our view, yeah, that's right. Some people may quit, maybe 3%. But more may quit when they discover they have to work together with unvaccinated others, because that means they may get the disease. Okay? And more will quit because they'll maybe die, or maybe they'll be in the hospital, or maybe they'll be sick and have to stay home for 2 weeks. So they did the pros and cons. So I'd like to take Justice Kagan's questions, which I think I share on the merits, and just ask you, are you asking us both still to issue a stay today, tomorrow, Monday, and why?
We are seeking an immediate, thanks for the question. We are seeking an immediate stay. As an initial matter, I think Alabama Realtors takes their arguments about the beneficial effects of their illegal action off the table. If the court considers it illegal, then it's not in the public interest and it's proper to enjoin it. Now, the court may say, or stay it rather, the court may decide that there's a better way to unwind the illegal action than a judicial action. I think that's what Justice Kavanaugh's concurrence in the first Alabama Realtors got to. But what it can't do is say, we judge that these are very, in our view, this illegal action will lead to good effects. And so we will allow that to happen. To Justice Kagan's question about the who decides point, Congress told us who decides. The 28 U.S.C. 2112 says that courts can issue stays. And the reason for that is they recognize that this was without notice and comment. And unless the courts could step in to abate illegal actions, nobody would be able to do so. And that's especially important here, where the action they're, in our view, mandating, but at least strongly encouraging vaccination cannot be undone. Finally, the other point of the public interest is that one awkwardness of this situation is that the ETS is focused on what was really a different pandemic. It's all about the Delta variant. Now we are on to Omicron. And as my presence here as a triple vaccinated individual by phone suggests, and as Justice Sotomayor suggests, and as the immediate brief from the American Commitment Foundation shows, vaccines do not appear to be very effective in stopping the spread of transmission. They are very effective in stopping severe consequences, and that's why our states strongly urge people to get them. But I think that makes it very hard to look at the numbers they give and assume that they still apply today.
Council, those numbers show that Omicron is as deadly and causes as much serious disease in the unvaccinated as Delta did. The numbers, look at the hospitalization rates that are going on. We have more affected people in the country today than we had a year ago in January. We have hospitals that are almost at full capacity with people severely ill on ventilators. We have over 100,000 children, which we've never had before, in serious condition, and many on ventilators. So saying it's a different variant just underscores the fact that without some workplace rules with respect to vaccines or encouraging vaccines, because this is not a vaccine mandate, and requiring masking and requiring isolation of people who have tested for COVID. Because none of you have addressed that part of the ETS is to say something that should be self-evident to the world, but is not, which is if you're sick, you can't come into work. The workplace can't let you into the workplace, and you shouldn't go on unmasked. Tell me what's irrational about rules of that nature when it is the workplace that puts you into contact with people that will put you at risk.
I don't know that we've argued that the requirement is irrational, and indeed, there may be many states subject to their own state laws that could impose this themselves or private businesses. So we're not making.
So if it's within the police power to protect the health and welfare of workers, you seem to be saying the states can do it, but you're saying the federal government can't, even though it's facing the same crisis in interstate commerce that states are facing within their own borders. I am not sure I understand the distinction why the states would have the power, but the federal government wouldn't.
The federal government has no police power.
Oh, it does have power with respect to protecting the health and safety of workers. We have accept the constitutionality of OSHA.
Yes, I think you'd be asking if they had police power to protect public health.
No, they have a police power to protect workers.
I would not call it police power. I think the Commerce Clause power allows them to address health. Sorry, that question. It allows them to address health in the context of the workplace.
Exactly.
It's a good time to move to our sequential questioning, Justice Thomas.
Mr. Flowers, there's been some suggestion, or at least it seems to be implied, that the vaccinations are efficacious in preventing some degree of infection to others. Could you talk about that, particularly as I remember in the filings, that the the younger workers, the 20-year-olds, who are unvaccinated are actually safer than the older workers who are vaccinated. So there are obviously some differences. Would you just talk about how efficacious the vaccine is in the workplace?
First, I want to be very clear. We are strong promoters of vaccination because they do stop serious illness. In terms of stopping infection and transmission, at least with the current variant, it appears, as the number suggests, to be far less effective. And then in terms of the comparison you were asking about, I think it's hard to define what the grave danger in the abstract. What we can at least mandate, or at least demand from the agency, is internal consistency. And if you look at their own data, the CDC data from the last week of October, unvaccinated individuals 18 to 29 were as likely to die as vaccinated 50 to 64-year-olds, and the 5 times less likely to die than vaccinated 65 and up. Hospitalization was between 18 and 49, that's not even just the young, was about as likely as vaccinated 65 and up. As you look at the Griffin study that they cite at 61,418 of the Federal Register, unvaccinated and vaccinated both had low risks of death in ICU. As a societal matter, we are not debating COVID is serious. It is an incredibly grave risk for some people, not for everybody. And finally, I'd point you to the Scobie study. Again, they cite that 61,418 of the Federal Register was that vaccinated individuals who are 65 or older are twice as likely to die as unvaccinated individuals 18 to 49. And keep in mind that's 18 to 49, not 18 to 29. So that's it'll probably be even more skewed if you look at the younger demographic.
Would the state of Ohio have in your, I'm not saying this would be an approach you would take, but you had earlier a discussion about whether or not the federal government had police powers in the workforce. And you suggested that the state has those police powers. Could the state of Ohio do what you say OSHA cannot do?
In terms of, yes, my position is the state of Ohio could mandate vaccinations not only for workers, but for all individuals. Now, I think that's an important point to stress, as we're talking here as though OSHA is the only entity that can regulate this, an agency that no one thought had anything to do with the pandemic until months, if not years into it. But we have the states and we have private businesses, and they're not sitting on their hands. And individuals are doing things to try and bring this pandemic to a close, or at least learn to live with it. Indeed, this court, without any requirement from OSHA, has found ways to safely conduct business.
I think my point is rather that there seems to be a suggestion that this is all or nothing, that the other governmental bodies do not have police powers to regulate certain activities. And you've answered my question. Thank you.
Justice Breyer?
A quick question. I'm just curious. I was searching for an example, universal risk inside and outside the workplace, including the workplace. Can OSHA regulate it? Can OSHA regulate fire risks?
Yes, we don't draw the distinction between.
If they can regulate fire risks, then why can't they regulate this risk?
Because the difference with the fire is that there's something about the workplace, for example, not providing safety equipment to put out the fire.
People throw matches. They smoke sometimes. Oh, they shouldn't, but they do. and or they throw a match, or they, a lot of causes, such as crushing people not crushing them. They come in the same room. You understand the point. Okay, the difference is, say it again so I catch it.
Sure, I want to be very clear about this. We accept the line that's been drawn forever in forging industries that simply the fact that a risk exists outside the workplace doesn't mean you can't address it when it's inside the workplace. What we dispute is the idea that a risk that is ever present in all places can be regulated simply because it's also in the workplace. And so you can regulate, to be clear. OSHA could regulate COVID-19 in the workplace when the employer does something like packing individuals very closely together in a poorly ventilated area that enhances or changes the nature of the risk, I should say. But that's not the risk they say they're regulating. Again, 61,411 of the Federal Register, they say the risk is you'll come into contact with individuals, and the risk of encountering an individual is an ever-present risk you face at home, at work, and everywhere else.
Justice Alito?
I want to come back to the question I asked Mr. Keller. In light of all that's been said this morning so far about public health, about the value of vaccines to the general public, because I want to make sure I understand precisely what the question is before us. And what I took from Mr. Keller's answer, which seems to be right, is that the question is whether there is a grave danger for unvaccinated workers, period. What the secretary said was, quote, employees who are unvaccinated are in grave danger from SARS, COVID virus, but employees who are fully vaccinated are not. So if this is to be sustained, it has to be on the ground that it presents a grave danger to unvaccinated workers who have chosen to be unvaccinated. That's my understanding of the issue, but maybe I haven't understood it correctly. Is that your understanding? And I'll ask the Solicitor General the same question, or at least I hope she will address it.
That is my understanding, and I don't see how there could be another understanding because the emergency provision specifically says that such emergency standard, meaning the precise one at issue, must be necessary to protect employees from the danger at issue. So the broad societal effects are not at issue.
And protection of vaccinated employees who may face some danger of contracting the virus was not the basis for this rule. Is that correct?
Correct, and I would go further and say they cannot rely at all on the risks of vaccinated workers because they conclude, this is 61,419 of the Federal Register, that no one who's vaccinated is in grave danger.
Thank you.
Justice Sotomayor?
Counsel, unvaccinated people you showed, or you pointed to young people who had a different or had the same death rate as vaccinated older people. But the point is that it's not the risk to the individual that's the question. It's that risk plus the risk to others. And unvaccinated people, and the agency has shown in its studies that unvaccinated people affect other unvaccinated people. And they vary in age and can be of ages and of conditions where the effect will be serious, if not death. So we're not talking, I don't know how comparing apples to oranges in terms of the risk factors makes any sense. But secondly, if the grave risk is to unvaccinated people, then how do we take that out of the equation? That it's not the risk just to them, but the risk that they pose to others, including unvaccinated people.
So I'll answer in two steps. On the apples to oranges, I think it's vital because they have to be internally consistent. And their own logic is that nobody who's vaccinated faces a great danger. So unvaccinated folks of certain ages are at lower risk of death and even hospitalization. That is relevant to calculate.
But lower risk doesn't mean no risk. And lower risk can go into the calculus of saying, we see, and that's what they said, the risk to unvaccinated people of all ages and all conditions. And when you remain unmasked or unvaccinated, you put yourself at risk, but you put others. Others unvaccinated people at risk and people who are vaccinated. They may be at a lesser risk, but the grave risk remains to people of all ages and conditions that are unvaccinated.
Right. But the problem is they've defined numerical probabilities that are equal to be grave in one case and not grave in the other, and that is the definition of irrational. In terms of spread, their own ETS is unclear the degree to which vaccinations reduce transmission. They appear to have a positive effect, and they appear, at least with Delta and previous variants, to stop contracting it in the first place. So again, if you look at the American Commitment Foundation brief, it's highly doubtful that the numbers are going to be comparable when it comes to the Omicron variant.
Justice Kagan?
Mr. Farr, I was just continuing on that. If I understand your answers to Justice Thomas and to Justice Sotomayor, you basically said a couple of things. You said, well, we understand that 18 to 29-year-olds, even though they're not going to die or wind up with very serious injuries, that they can spread. You don't doubt that those people spread to other people who might be more vulnerable. You don't doubt that, right?
That's right, but the problem.
Okay, so just I'm sorry to cut you off, but I just wanted to state that as like the premise. And then the question is, well, you said, well, the agency itself says that the danger is to other unvaccinated people, older people, immunocompromised people, whatever. And you seem to be saying that because it's to other unvaccinated people, they assumed the risk and the agency's power runs out. Is that what you're saying? Because I don't know about that kind of doctrine in the OSHA Act or any place else in administrative law, that because you can say that, somebody would prefer not to be regulated, the agency loses its power.
That's not quite the point we're making. It goes to 2 points. The first is necessity. So if everyone who's vaccinated is not in grave danger, then a narrower solution is if they think they have the power to vaccinate, to require the people in grave danger to be vaccinated, and they are removed from the grave danger, and the other individuals are not affected. I think that's the key point there.
Okay, thank you. Justice Gorsuch?
Mr. Flowers, I'd like to return to the question of who decides. I think we've all kind of come to the point where we all agree that states have wide police power under our constitutional system. Congress has to regulate consistent with the Commerce Clause and make the major decisions, while agencies can do the work that Congress has given them to do, but not other kinds of work. And the major questions doctrine kind of regulates that interaction between Congress and agencies. So it's not that judges are supposed to decide some question of public health. It's about regulating the rules of the system to ensure that the appropriate party does. And so the question, in my mind, really turns a lot on the major questions doctrine in this case. Is this one that has been given to the agencies to decide, or one that Congress has to make as a major question under our federal system? And I haven't heard a lot of discussion about that. The Solicitor General says the major questions issue only comes into play when a statute's ambiguous. I'd like to give you an opportunity to explain your view.
I think you can view the major question doctrine, the phrase is sometimes used in different contexts, and sometimes it is used as kind of an ambiguity clarifier, an elephant's and mouthful's point. But another way to look at it is something of a constitutional doubt canon, where we recognize that although our non-delegation doctrine is not especially robust today, there are limits on the amount of authority that Congress can give away. And with respect to these major questions that are going to affect people from coast to coast and cost millions and millions of dollars, or potentially many jobs, and potentially affect public health, we would expect Congress, we would demand Congress to at least speak clearly before we will say an agency can exercise that power, and therefore before we're into the non-delegation issue. I do want to stress a non-delegation. I mean, if they're right about work-related danger, because I understand their rule, it's any danger you could possibly face at work. A grave danger is any danger that could even conceivably result in death. Necessary means useful, and through a temporary and emergency standard, you can require permanent abatement. If you put all that together, this is among the broadest and most standardless delegations of authority to an agency in the United States Code.
Justice Kavanaugh?
Yeah, I want to follow up on Justice Gorsuch's questions, which I think are important, and also Justice Kagan's questions about the policy arguments that are present here, especially in an emergency situation. So, as I understand it, you're invoking the major questions doctrine and your statutory argument to say that based on the Constitution's separation of powers, Congress must act or the states must act, and OSHA lacks authority under the current statutes to do this. That's your basic pitch, I think.
I think so, as long as this means the vaccine mandate. We're not disputing that they can regulate COVID-19 to some degree.
Okay. Yes, that's what I meant by this. I want to give you an opportunity to explain the value of insisting on that congressional action for something like this at the federal level in an emergency situation, and explain why we shouldn't defer more to the executive or defer to the executive in what has been characterized, I think appropriately, as a crisis or an emergency kind of situation. What's the value of insisting on that here?
Well, one value of it is that when there's an emergency, it's especially important that it be a considered thoughtful process, and legislation is more likely to yield that. And in an emergency, you're more likely to get broad agreement on certain principles that can be enacted through Congress. And indeed, Congress has taken many steps to ensure that there are to address COVID-19.
Thank you.
Justice Barrett? Thank you, counsel.
For those who have asked, I don't block any comments. That's YouTube.
May it please the court. COVID-19 is the deadliest pandemic in American history, and it poses a particularly acute workplace danger.
Workers are getting sick and dying every day because of their exposure to the virus at work. OSHA amassed substantial evidence of widespread workplace outbreaks across all industries. It studied the science of how this virus is transmitted and found that workers are exposed to danger when they're inside together for as little as 15 minutes. And OSHA considered the extensive evidence that unvaccinated employees are at heightened risk of contracting the virus, of transmitting it to others and infecting their coworkers, and of suffering the gravest consequences, hospitalization, and even death. To protect against that grave danger, the standard requires employers to adopt a policy that unvaccinated employees either get vaccinated or mask and test. Those are commonplace and highly effective measures that OSHA determined were essential to stopping the spread of this dangerous disease at work. The applicants try to portray this standard as unprecedented, but this lies in the heartland of OSHA's regulatory authority. Congress charged the agency with setting nationwide standards to protect the health and safety of employees throughout the nation, and Congress specifically appropriated money to OSHA to address COVID-19 in the workplace. Nothing in the statute or the agency's regulatory history bars the use of these measures. Just the opposite. Section 669A5 of the OSH Act specifically contemplates that immunization requirements can be imposed under the Act, and OSHA has previously protected workers with measures like masking, testing, and encouraging vaccination. OSHA had statutory authority to rely on those measures here, which it found would save 6,500 lives and prevent 250,000 hospitalizations in just 6 months. As the preamble to the standard explains, exposure to COVID-19 on the job is the biggest threat to workers in OSHA's history. The court should reject the argument that the agency is powerless to address that grave danger. I welcome the court's questions.
General, what's the problem you're getting at? Is it the employer not providing, making sure that employees are vaccinated or masked, or is it the employees who decline to be vaccinated or masked?
Well, it's the grave danger to exposure to COVID-19 at work, Justice Thomas.
Who refuses to do that?
Ultimately, what the agency is doing with these standards is requiring that either through a vaccination requirement or through a masking and testing policy, that unvaccinated workers who stand the highest chance of contracting the virus at work, of infecting others at work, and then ultimately if they get if they catch COVID at work, of then suffering death possibly or even hospitalization, are protected in all of those circumstances. So I think what this standard does is it regulates employers by requiring them to adopt a policy that will directly target that grave danger.
I understand that, but who is declining to do that? Is it the employer or the employee?
I think it can be both. There are many employers around the country that have voluntarily imposed these kinds of requirements with their workers in recognition that vaccination is the single most effective way to protect workers in the workplace, or that have used masking and testing requirements to the same end. So many employers are doing it, but part of OSHA's function and what Congress charged the agency with doing is to look at those kinds of best practices and impose them through standards to ensure that workers, no matter what specific controls their employers have in place, are maximally protected.
One last question. I think you put quite a bit of weight on the acute crisis that we're in. But would your argument be the same for any infectious disease that is taken into the workplace?
No, I think that with respect to other infectious diseases, it would be necessary for OSHA to develop the record to demonstrate that the requisite risk level that the statute requires is satisfied.
It's not that you would do it, but could you do it?
If there were, in fact, a grave danger to employees posed by another infectious disease, then yes, we think that Congress clearly contemplated that OSHA is obligated and charged with the responsibility.
Has OSHA ever done that?
OSHA has enacted any number of standards that address those kinds of threats. For example, the bloodborne pathogen standard that we have pointed to before was intended to protect employees from the risk of viruses that they can contract through bloodborne transmission. So is that in the general workplace or just in healthcare? That standard applied anywhere where employees can predictably encounter bloodborne pathogens. So it wasn't just the healthcare context. It can apply to flight attendants. It can apply to janitors. It was a standard that directly targeted the exposure wherever it exists, just like this one does.
Thank you.
General, you said just a short while ago that this presented, COVID presented a grave danger to people in the workplace. In a few minutes, we'll hear an argument in the CMS case, and it would be that it presents a grave danger into Medicare and Medicaid facilities. Not here, but in the lower courts, the federal contractor mandate, the argument is going to be it's a grave danger to federal contractors. Could you give me examples of some federal agencies where you would be willing to say COVID is not a grave danger in that context?
Well, Mr. Chief Justice, I haven't, of course, surveyed the landscape of all of the different authorities that federal agencies can invoke.
No, but you represent them on a regular basis here, so you have a pretty general idea of some other examples of federal agencies. And my point, obviously, is that I don't think as more and more mandates and more agencies come into place, it's a little hard to accept the idea that this is particularized to this thing, that it's a OSHA regulation, that it's a CMS regulation, that it's a federal contractor regulation. It seems to me that it's that the government is trying to work across the waterfront, and it's just going agency by agency. I mean, this has been referred to the approach as a workaround, and I'm wondering what it is you're trying to work around.
What we're trying to do here, and what OSHA did, was rely on its express statutory authority to provide protection to America's workforce from grave dangers like this one. So I take the point and don't dispute that COVID-19 is a danger in many contexts and falls within the jurisdiction of other agencies as well. But I think to suggest that because this disease is so prevalent, because it presents such a widespread harm, somehow OSHA has less power to do anything about it with respect to
No, it's not so much that OSHA has less power. It's that the idea that it's specific to particular agencies really doesn't hold much water when you're picking them off one by one. I think maybe it should be analyzed more broadly, as this is in effect an effort to cover the waterfront. I'm not saying it's a bad thing, but I don't know that we should try to find, okay, what specific thing can we find to say, oh, this is covered by OSHA? What specific thing can we find to say that this is covered by the hospitals? What specific thing can we find to say, oh, no, we're doing this because this is a federal contractor? It seems to me that the more and more mandates that pop up in different agencies, it's fair. I wonder if it's not fair for us to look at the court as a general exercise of power by the federal government, and then ask the questions of, well, why doesn't Congress have a say in this, and why doesn't this be the primary responsibility of the states?
Congress absolutely has a say in this, and it spoke here. It passed the OSH Act and promulgated Section 655C specifically to empower OSHA to take action to protect workers from grave dangers.
When did it do that?
The OSH Act was enacted in 1970, I believe, and the agency, as it explained in the preamble to this rule, documented substantial evidence to show why this constitutes a grave danger.
Well, I don't think you can say that that's specifically addressed to this problem.
Well, Mr. Chief Justice, the court obviously has a statute in front of it that it needs to examine. I think that there is no doubt that COVID-19 constitutes a physically hazardous agent within the meaning of this provision. I think that the immediacy and magnitude of harm here clearly constitutes a grave danger. Unvaccinated workers stand a 1 in 14 chance of being hospitalized, a 1 in 200 chance of dying. The country hasn't seen numbers like that.
It sounds like the sort of thing that states will be responding to or should be, and that Congress should be responding to or should be. Rather than agency by agency, the federal government, the executive branch acting alone is responding to. And we're supposed to say, well, yes, this is a CMS problem. Yes, this is an OSHA problem. Yes, this is a federal contractor problem. The military is on its own. They take orders. I guess I'm just repeating myself. It seems to me that we should be looking at it as an across-the-board issue. As opposed to, let's see what OSHA looks like. Let's see what CMS looks like.
Well, General, I'm sorry, go ahead.
I was just going to say, Mr. Chief Justice, that I think the court, in approaching issues of statutory interpretation and looking at agencies' regulatory authority, has always started with the text that Congress enacted for purposes of understanding whether the agency has power to act. And the fact that there are other agencies here that likewise we think are empowered to act to protect America against what is happening in this country right now shouldn't diminish the force of the express statutory authorization
But I think the
here.
question is this. I mean, it is a rather deep, in a sense, deep question. Can you review it? Could the White House say, issue an order to all federal employees? And what it says is every federal employee in any agency who has authority under a statute, which means all of them, to require those whom they regulate to insist that their employees be vaccinated, do it. Now, they can't legally tell you do it, but it's a strong policy. And that's what's happened. Now, I don't know the implications of that. I never thought of that. But I think that's what you're being asked. And I don't know you ever thought of it. But I mean, has that happened?
I think it's incorrect to say that that is what is happening here. This policy.
Yeah, but I mean, has that happened generally? Has that happened? Did somebody issue such an order?
Justice Breyer, standing before you today, I'm not sure that I can think of a precise historical example of
No,
that
I
kind of
mean, in
order.
this instance, your answer, I take it, is no. There is no such order.
That's right. I mean, certainly, I think that that throughout this nation.
I don't want to put words in your mouth. Don't tell me there isn't such an order if there is.
No, I'm not aware of any such order.
All right, or something like that. Okay. I have one other question, which is because I'm operating between two things. One is the merits, which might be difficult. I don't know. I'm not taking a view on that. But at least they're difficult and could take time. And the other is the question of the stay. Now, on the question of the stay, I read from research that we've done, but I don't know if it's right, that the argument was, what about the argument that they've made? One is that, well, if we issue a stay today, tomorrow, more people will stay home and things will get worse. Okay? That was one of their arguments. And the other, well, all right, what about that? That seemed to me to be the main one.
As I understand the argument, they're concerned about worker attrition with respect to that particular claim. And the agency gave sustained attention to this very issue. It spans several pages of the Federal Register. The agency looked at surveys that attempt to analyze how workers will respond. It looked at the real on-the-ground practical experience of companies that had imposed these kinds of mandates and found that there was substantial compliance levels and that the concern that workers would leave in droves was misplaced. And then the agency further emphasized that it had provided flexibility to employers to adopt a mask and test policy instead of a vaccination requirement, specifically because the employers are best positioned to understand their workforce and to know which of these options is going to ensure maximum
What
compliance.
about on the merits? I just have one other, which is on the merits. You've heard and you've read the argument on the other side that, look, what the OSHA could easily have done or should have done is go through industry by industry or groups of industries by groups of industries and say there's this here and there's that there. Instead, what they did is everybody over 100 employees, except for, and then they had a few exceptions, working alone, working at home, religious exemption. You can prove to us that you have some other thing that's just as good. You know, they went that way across industries instead of one by the other. That's one of their arguments. What would you say to that?
My response to that is that the secretary here cited overwhelming scientific and medical evidence that the grave danger exists based on how this virus is transmitted anywhere people gather indoors together. And that applies to a lot of workplaces, but that just turns on the nature of how this virus is communicable between people. As Justice Kagan noted, often employees have little control over their work environments. They can't control whether they can socially distance, who they come into contact with, what precautions those people are taking, what ventilation systems exist. And ultimately, OSHA determined that anywhere there is a risk of indoor transmission, there is a grave danger to unvaccinated employees. Now, I take the point, as the Chief Justice's hypothetical focused on, I think Justice Barrett focused on this as well, that there are certain workplaces, factories, assembly lines, where the risk is even graver, where the danger and the chance of transmission is heightened. But I don't think that that in any sense calls into question the Secretary's determination that there is a baseline grave danger in any work site where that inside risk of transmission can occur.
General, can we, I'm sorry.
Justice Alito? I just wanted to ask you a question on this issue of the commencement of enforcement and the issuance of stay. This ETS was issued a couple of months ago, isn't that right?
On November 5th, that's correct.
Yeah, November 5th. All right, and it hasn't been enforced during that period. These cases arrived at this court just a short time ago. They present lots of difficult, complicated issues. We have hundreds of pages of briefing. We're receiving very helpful arguments this morning. Does the federal government object to our taking a couple of days, maybe, to think about this, to digest the arguments before people start losing jobs?
Well, Justice Alito, if you're asking whether it would be appropriate for the court to issue a brief administrative stay, certainly we think that that would be within the court's prerogative if it thinks that it's necessary to do that. Ultimately, for the injunction that they're actually asking for here, the applicants would have to show an indisputably clear right to relief, which we think they can't satisfy.
Well, I'm asking about an administrative stay, and I won't get into an argument about indisputably clear, but your point is, you think it would be appropriate or it would not be appropriate if we issued a short administrative stay? Or if we do that, are you going to say, well, they're causing people to die every day?
We do think that the agency found that there is grave harm every day, and the numbers are stark.
But there was that grave harm during every single day.
Hospitalizations over.
Was there not that same grave harm during every single day between the time when this was issued and today?
Well, certainly, we think that the harm has existed and been present throughout, and the agency specifically set aggressive compliance deadlines.
Well, my answer, I asked a really simple question, and you have the prerogative to say, no, we think, horrible consequences are going to ensue if you issue even an administrative stay of a short period of time, and we don't think that you need to have that time to digest this case and decide it.
I'm not going to say that, Justice Alito. If the court believes that it needs a brief administrative stay, then of course it can enter it.
And you mean brief, don't you?
Yes, we think that there are lives being lost every day.
Well, brief compared to what? The months that it hasn't been in effect since November, whatever it is, when the courts have been active in this area, or brief compared to what?
Well, Mr. Chief Justice, I think that the agency well explained that the employers who are covered by this needed time to come into compliance. The agency announced that it was exercising enforcement discretion because of the confusion that had been created by the Fifth Circuit stay. Maybe it would be helpful for me to explain exactly what the January 10th deadline means with respect to compliance. The agency has announced that for employers who are acting in good faith, it is not going to enforce any of the provisions of this ETS until January 10th. And what that means as a practical matter is that employers need to be adopting their policies. And they need to be ascertaining the vaccination status of their employees. And as of January 10th, they need to be requiring masking for any employees who remain unvaccinated. So it's not as though immediately employees are going to be quitting their jobs or leaving in response with the worst predictions. On January 10th, if this standard remains in effect, then masking will immediately be required and the testing will kick in on February 9th.
So if we delay that one day, maybe I'm wrong, and please tell me if I am, but the numbers I read is when they issued this order, there were approximately 70-something thousand new cases every day. And yesterday, there were close to 750,000. So if we delay it a day, and if it were to have effect, then 750,000 more people will have COVID, who otherwise, if we didn't delay it, wouldn't have. I mean, I don't doubt the power of the court to issue a stay. I'm just saying, what are the consequences of that? And if I'm wrong, you better tell me I'm wrong, because I thought that it really did make a difference to people who might get, you have the numbers, I saw the numbers. Well, all right, so what do you say? Now you say that's not really not a problem?
Justice Breyer, we absolutely agree that this pandemic has been dynamic, that it is constantly evolving, and that the current conditions are posing a truly grave danger.
General, am I to understand from your previous answer that enforcement qua testing doesn't occur till February 9th, correct?
That's correct, Justice Sotomayor.
The only thing that would happen in the next few days, or up to now, everybody should have a plan in place, correct?
Correct.
There's been no stay. So starting tomorrow, the only thing that are required are masks, correct?
Masking for unvaccinated workers, that's correct.
That's the only thing that occurs. And so until February 9th, when the testing comes into effect, that's when the threat of resignations or expense comes into effect, correct?
Yes, as I understand what the applicants are arguing here
So
on the testing aspect.
So the need for an administrative stay, if we're talking about a few days, is really small, if very small, correct?
I certainly, myself, do not think an administrative stay would be warranted here, but I, of course, defer to the court on that.
All right, one other question, if I might, counsel. I want to go back to the Chief's question and to Justice Thomas's question, and in part to Justice Gorsuch's questions earlier. The issue of who should act and who can act. An agency takes a while to act, and it's acting under an emergency order or an emergency statutory delegation by Congress. And the chief says Congress should act. We shouldn't let every agency act. Could you speak about the relative both expertise and speed with which Congress can act to survey the countless work sites in our economy, to identify the health and safety hazards in each one, and to legislate with the granular specificity necessary to address the hazards in all of these different workplaces? I understood the fact that in an emergency, we should not violate the Constitution. But I'm not quite sure what regulation of safe and healthy, what provision of the Constitution it violates. But I want you to get to the general question some of my colleagues have raised. Who's in a better position to act and why? And why is it in a better position to act constitutionally?
Yes, of course, Justice Sotomayor. To be clear, we think that Congress has already acted here in passing Section 655C to authorize OSHA to take this kind of swift action in response to an emergency situation. If you look at the plain text of the statute, we think that OSHA's standard clearly falls within the terms that Congress enacted. COVID-19 is a grave danger. It's a physically harmful agent, and the agency found that these measures are essential to protect workers. So we think that the statutory language already exists. Now, to the extent that the applicants are suggesting that there's some kind of specific authorization requirement here, that Congress had to do more, I think that gets to the heart of your question, which is that when this court has interpreted statutes before, it hasn't departed from plain meaning and imposed that kind of burden on Congress to legislate with that specificity and that granularity, particularly in an emergency situation like this one. And the applicants have pointed to no aspect of the statute that would warrant that kind of result here. It's their interpretation that runs counter to express statutory provisions, Section 669A5, that specifically contemplates that immunization requirements can be imposed, the American Recovery Plan Act that where Congress specifically appropriated $100 million to OSHA and directed it, in the words of the legislation, to carry out COVID-19 related worker protection activities.
Well, you're saying that Congress acted. Don't complain that Congress hasn't done anything, and that that was 50 years ago that you're saying Congress acted. I don't think it had COVID in mind. That was almost closer to the Spanish flu than it is to today's problem. Now, I understand the idea that agencies are more expert than Congress. I understand the idea that they can move more quickly than Congress. But this is something that the federal government has never done before, right? Mandated vaccine coverage.
It's true that there has been no standard that looks exactly like this one. The federal government has encouraged vaccination, as this standard does, and other provisions like the bloodborne pathogen standard. And masking and medical testing of employees are common features of OSHA standards.
Is it that an important consideration that we should take into effect? For example, along with the fact that the police power to take such action is more commonly exercised by the states, and we've had many cases coming out of the states and municipalities that evidence that, and also that it's 50 years ago Congress passed a general provision, but I think it's certainly hard to argue, and you're doing a good job of it, that gives free rein to the agencies to take, I guess this is invoking the major cases doctrine, that it gives free rein to the agencies to enact such broad regulation that was certainly unfamiliar to Congress in 1970.
Well, there are a lot of elements to that question. I'd like to try to take them in turn. I think that Congress did specifically contemplate that there would be emergency situations that pose grave dangers to workers throughout America, and it specifically empowered OSHA to take action in response to that. I understand the suggestion here that the standard is unprecedented, but I don't think it withstands scrutiny. If you look at the various claims that the applicants are making, they first object to the scope of the standard, the number of employers who are covered, but OSHA commonly issues nationwide standards that govern all employers throughout the nation with respect to risks that exist throughout the nation, and that describes COVID-19. There is substantial evidence here to justify the scope of the standard.
Go ahead.
And just to close the loop with one final response, which is to focus on the particular mitigation measures, there too, we think that there is no indication that Congress couldn't have anticipated or intended OSHA to use these types of measures to combat a deadly virus at work. Immunization is specifically referenced in Section 669A5. It is the single most effective way to target the spread of a deadly virus. And to think that Congress would have meant to preclude OSHA from encouraging vaccination, I think is inconsistent both with the text of the statute and with the broader history of immunization requirements in this country, which have commonly been imposed.
Thank you, Counsel. Justice Thomas, anything further?
I'm curious. This probably doesn't go to the dispositions matter, but is a vaccine the only way to treat COVID?
It is certainly the single most effective way to target all of the hazards OSHA identified, both the chances of contracting the virus in the first place, the risk of infecting other workers on the work site, and with respect to the negative health consequences. That vaccination provides protection on all of those fronts.
Thank you.
Justice Breyer, anything further? Justice Alito?
On the issue of whether you're trying to squeeze an elephant into a mouse hole, and the question of whether this is fundamentally different from anything that OSHA has ever done before, I want to see if it might be fundamentally different in at least two respects and get your answer to the question. Most OSHA regulations, all of the ones with which I'm familiar, affect employees when they are on the job, but not when they are not on the job. And this affects employees all the time. If you're vaccinated while you're on the job, you're vaccinated when you're not on the job. Isn't this different from anything OSHA has done before in that respect?
So two responses to that. First, of course, there's also a mask and test option here. So I think even on that analysis.
Right now I'm talking just about the vaccine.
So focusing just on vaccination, I think that that's a way to describe it, that it also provides protection when you're not at work, but OSHA was directly targeting and trying to provide the protection at work. And I don't think there's any basis in the text of the statute to think that this kind of protection is off limits.
Suppose this is a little science fiction, but maybe it will illustrate a point. Suppose that this protection were provided not by the administration of a vaccine, but by waving a wand over employees when they arrive at work. And suppose that wand also had the capability of taking away this protection when the employee leaves work. Would OSHA have the authority to tell employees, you must have this wand waved over you when you arrive, but you can't have it taken off when you leave?
No, I don't think that OSHA would have that authority.
All right, so it's different in that respect. And here's another respect in which it may be different. And I don't want to be misunderstood in making this point because I'm not saying the vaccines are unsafe. The FDA has approved them. It's found that they're safe. It's said that the benefits greatly outweigh the risks. I'm not contesting that in any way. I don't want to be misunderstood. I'm sure I will be misunderstood. I just want to emphasize I'm not making that point. But is it not the case that these vaccines and every other vaccine of which I'm aware and many other medications have benefits and they also have risks? And that some people who are vaccinated and some people who take medication that is highly beneficial will suffer adverse consequences. Is that not true of these vaccines? And if that is that true?
That can be true, but of course there is far, far greater risk from being
But there
vaccinated,
is
by orders of magnitude.
right. There is some risk. Do you dispute that?
There can be a very minimal risk with respect to some individuals, but again, I would emphasize that I think that there would be no basis to think that these FDA-approved and authorized vaccines are not safe and effective. They are
No,
the
I'm not
most
making
effective.
that point. I tried to make it as clear as I could. I'm not making that point. I'm not making that point. I'm not making that point. There is a risk, right? Has OSHA ever imposed any other safety regulation that imposes some extra risk, some different risk on the employee? So that if you have to wear a hard hat on the job, wearing a hard hat has some adverse health consequences. Can you think of anything else that's like this?
I can't think of anything else that's precisely like this, but I think that to suggest that OSHA is precluded from using the most common, routine, safe, effective, proven strategy to fight an infectious disease at work would be a departure from how this statute should be understood.
Can I just say, General, that regulators think of risk trade-offs constantly when they make regulations. That there are constant situations in which there are risk trade-offs. Risks on both sides, but one risk vastly outweighs another risk, and that comes up throughout regulatory space.
That's absolutely true. And one of the risks that OSHA was guarding against here was the risk that unvaccinated workers pose to other workers because they're so much more likely to transmit this deadly disease
What
to
type
them.
of workers? To vaccinated workers?
Yes, the grave danger
I
finding
thought
is
the
based on
secretary
unvaccinated
disclaimed
workers.
that.
Yeah, the grave danger finding is limited to unvaccinated workers
Right,
who are
so
far
that's
more
not
likely
a
to
concern
contract it
for
from their
us.
coworkers
That's
as
not a
well.
concern for us, is it? We can't sustain this on that ground, that this is helpful to the vaccinated workers because the unvaccinated workers present a risk to them.
Oh, to be clear, they present a risk to other unvaccinated workers who
All of
might
whom
be
have-
older, who
all
might
of-
have other
all of whom
comorbidities.
have balanced the risks differently, maybe very foolishly, but they want to balance the risks presented to their health in a different way. And OSHA says, no, you can't do that. And that applies when you're on the job and also when you're not on the job and for the rest of your life because you have to take these vaccines, unless the testing option is valuable.
Well, one small factual correction, if I could, and then a broader legal point. I think it's wrong to say that everyone who's unvaccinated is just assuming the risk. Some people can't get vaccinations for medical reasons. Some people have deeply held religious beliefs and are entitled to religious exemptions. And OSHA is entitled to try to protect those unvaccinated workers, no matter the reason they're unvaccinated. Just on the broader legal point, the idea that OSHA is powerless to act to protect workers if they simply want to assume the risk is inconsistent with how the OSHA Act has been understood throughout its history. OSHA frequently requires employers to require that the employees use protective gear or take precautions.
Isn't it the case that most of the time there's this strong reason for saying that it isn't a defense to an OSHA Act charge that the employers assumed the risk voluntarily, that under most circumstances, employers have an incentive to avoid compliance to avoid the costs and inconvenience of a regulation. And so we don't want to put the employees under pressure, overt or implied, to waive the protection of a regulation, a protected regulation. But there's no such incentive here. They're free, the vaccines are free, and to the extent they keep workers healthy and on the job, it's in the interest of the employers to have them vaccinated.
Well, certainly the fact that workers in the past have not wanted to use certain protections has not provided a defense to regulations that have been issued under the OSH Act.
Counsel, if I might just go back to Justice Alito's question, there's no vaccine mandate here, correct?
That's correct, and that's what I started with, that of course any employer can opt for the mask and test option instead.
So really the question is between masking and testing and or vaccine, but no employer is being put at risk greater than they choose to undertake themselves, correct?
Yes, the employers have a choice to adopt either of those policies, and OSHA estimated that 40% of employers would adopt the mask and test policy.
Number two, with respect to the issue of whether a person has chosen to run the risk by being unvaccinated, you point out that some people can't for a variety of different reasons. But the risk here is not just to the person, it's to everybody else they put at risk, correct?
That's correct. The grave danger finding was premised on unvaccinated individuals, but OSHA emphasized that ensuring that unvaccinated individuals are not spreading the virus in the workplace will protect everyone they come into contact with.
So they may not be a grave danger to other people, but I don't see why OSHA has to close its eyes to the fact that they place grave risk to unvaccinated and substantial risk to other people, correct?
That's right, and OSHA specifically emphasized that vaccinated individuals may still be at significant risk. It wasn't ruling out that possibility. Its grave danger finding was focused on all of the ways that being unvaccinated contributes to the spread of this disease.
Thank you, Counsel.
Is the testing alternative viable at the present time in light of the stories that we see about the long lines that are required to be tested?
The agency gave sustained attention to testing capacity in the preamble to the rule. It looked at existing testing capacity and projected out of what additional capacity would be necessary for employers that choose to adopt the mask and test policy, and concluded that there would be ample testing in order to comply with the rule. I'm obviously familiar with the news stories that you're referencing, and I think that the agency could adjust if that proves to be a problem. But with respect to reviewing this rule, there was certainly a substantial basis for the Secretary to conclude that this was a viable option.
Justice Kagan? General, I'd like to ask the government's views of the major questions doctrine that a number of my colleagues have asked about. And as I see it, there are sort of two ways that such a doctrine could operate. One is with respect to ambiguous statutes, ambiguous either because they're vague or because there are statutes that seem to have conflicting provisions, where they point both ways. And then the major questions doctrine is an aid to interpretation of that statute. It's essentially a kind of clue about how you should interpret a very difficult to understand statute. And the second way is there's really nothing difficult to understand about this. The agency action falls within the scope of the statutory authority. There's just no question that it does. And yet, because the agency action is kind of a big deal, we're just going to ignore the fact that it falls clearly within the scope of the delegated authority and say that notwithstanding that that's true, Congress has to re-up it. So I think I'd like you to talk about those two versions of the major questions doctrine with respect to this rule. What do you think of those two versions, and which of the versions potentially applies here?
I think that perfectly encapsulates the two versions, and we think that this court's precedents clearly demonstrate that it's the first version that you articulated is the way that the court has previously considered economic and political consequences. So it's never been the case that the court has started at the outset by saying, does this seem like a big deal? Does this agency action have a lot of consequences? And then use that as a basis to depart from the plain language of the statute, or to say Congress has to specifically authorize it. We're not going to give the statutory text its ordinary meaning. Instead, in the cases where the court has looked at those kinds of consequences, it has always identified a conflict with other express statutory language, a conflict with other statutes that Congress has enacted that directly address the issue of question, or a conflict with the entire structure of the statute such that it would be unrecognizable to the Congress that enacted it. And it's only been in those situations where the court has identified a textual and structural problem with the agency's interpretation in the beginning, using those traditional tools of statutory construction, that the court has then gone on to say that its interpretation of the statute is confirmed by the economic and political consequences that would ensue. So I think it would be a sea change for this court to reverse the order of operations as the applicants are asking for here, and to start off by asking, does this seem like it has economic and political consequences? And it would ultimately do a disservice to principles of the separation of powers and to Congress's ability to have its clear statutory enactments, even if they're broad, given the effect that they have.
Mrs. Gorsuch?
Yes, so my question with respect to the major questions doctrine is this, we accept that it's not our role to decide public health questions, but it is our important job to decide who should decide those questions. I think we all agree on that. And here our choice on one hand is a federal agency, and on the other hand, the Congress of the United States and state governments. Now you argue we should not consider the major questions doctrine unless and until we find a statutory ambiguity. I understand that. But let's say the court does find such an ambiguity. I know you'll contest the premise, but let's just work on it. If there is an ambiguity, why isn't this a major question that therefore belongs to the people's representatives in the states and in the halls of Congress, given that the statute at issue here is, as the Chief Justice pointed out, 50 years old, doesn't address this question. The rule affects, I believe, we're told 80 million people, and the government reserves the right to extend it to every private business in the country. Traditionally, states have had the responsibility for overseeing vaccination mandates. I rejected a challenge to one just the other day from New Mexico. Congress has had a year to act on the question of vaccine mandates already. As the Chief Justice points out, it appears that the federal government is going agency by agency as a workaround to its inability to get Congress to act. The risks imposed here are not unilateral. There are risks to those who choose not to be vaccinated that they're trying to avoid sometimes, as you discussed with Justice Alito and conceded to him. Traditionally, OSHA has had rules that affect workplace hazards that are unique to the workplace and don't involve hazards that affect individuals 24 hours a day. So that's kind of the general tick list we have before us. And I'd just like you to address, again, the question, assuming the statute's ambiguous, why isn't this a major question that normally under our Constitution would be reserved for the people's representatives in the states, in the first instance, and in the halls of Congress in the second?
So accepting the assumption that there's an ambiguity, which of course we disagree with, as you know, I think that many of the factors you identified are just simply inconsistent with the whole premise of the OSH Act. So it's true that states have a police power over health and safety, but as this court recognized in the Gade case, Congress, in enacting the OSH Act, specifically brought the federal government into the role of protecting the health and safety of America's workers and displacing and preempting state law in that field. And so I think the idea that simply because states have that residual police power provides a basis to assume that the OSH Act can't have any application or that there has to be a specific authorization here of each and every type of mitigation measure is just fundamentally inconsistent with Congress's policy as embodied in that act.
What do we make of the fact that Congress, that OSHA has not traditionally mandated other vaccines for other hazards that could pose a grave risk, some might say? The flu kills people every year. Other grave diseases do too. And there are vaccines against many, and we don't need to list them all. But traditionally, OSHA has not regulated in this area.
I think that that's explained by the fact that COVID-19 is an unprecedented pandemic that has a magnitude and proportion that OSHA has never seen before.
I mean, people forget polio. Well, that was pretty bad. You can call it a pandemic, you can call it an endemic, I don't know what you'd call it. But it was a terrible scourge on this country for many years. And we have vaccines against that. But the federal government through OSHA, so far as I know, and you can correct me, does not mandate every worker in the country to receive such a vaccine. We have flu vaccines. Flu kills, I believe, hundreds of thousands of people every year. OSHA's never purported to regulate on that basis. What do we make of that when we're thinking about what qualifies as a major question and what doesn't?
Well, with respect to other diseases where there are effective vaccinations, I think the simple explanation for why OSHA hasn't had to regulate workplace exposure to that is because virtually all workers are already vaccinated. With respect to many of those diseases, all of us have at one time or another been subject to compulsory
Is that
vaccination
true with the
requirements
flu?
mostly.
Do we know that to be true with the
So
flu?
flu is an exception because it's a seasonal illness. And there, I think that the explanation for the failure to regulate is that it doesn't present anything approximating the kind of hazard or danger to workers as COVID-19. I don't want to suggest that
Are
it
you
would be,
suggesting that it doesn't pose a grave risk?
I think that the agency would have to build the record to demonstrate that it would clear that statutory hurdle.
But it might.
It would depend on the evidence. Certainly, if there were another 1918 influenza outbreak like the country experienced before, yes, absolutely. I think OSHA could regulate exposure to influenza in the workplace. That's similar to what's happening with COVID-19 right now.
Justice Kavanaugh?
I want to follow up on Justice Gorsuch's and Justice Kagan's questions with how the major questions doctrine applies, and really first zero in on this question of ambiguity. We've used words like vague, subtle, oblique, cryptic, and ambiguous to describe the kind of language that would trigger the major questions doctrine if it is a major question. We haven't only used the word ambiguous. And it seems to me that a question that I'd like your help on is applying language that is subtle, cryptic, oblique to a new context hasn't been done before in the last 50 years. How do we think about a question like that? And in answering that, think about the benzene case, the Brown and Williamson case with tobacco, benzene with cancer, and the UARG case with greenhouse gas emissions. All three where the agency was applying this broad but arguably cryptic language to a new context. I think that's one way to characterize them. How do we think about that?
Well, I think Justice Kavanaugh, looking at those three cases in particular, that the reason the court concluded that the language was cryptic or oblique was because it identified other textual or structural reasons that ran counter to the agency's interpretation. So in the utility air case that you referenced, the court observed that the asserted regulation would overthrow the entire statutory scheme. The agency had conceded that it was never what Congress could have possibly intended. So that was a structural indication that the agency's regulation was impermissible. With respect to the benzene case, there too, there was a question about whether there was an entitlement to regulate without any finding of risk, and that was in tension with other statutory provisions, so there was a conflict. And with the Brown and Williamson case that you mentioned, the court chronicled a long line of statutes that had directly addressed the issue of regulation of tobacco products and would have been flatly inconsistent with the agency's asserted jurisdiction. So there's never been a case where the court has just confronted broad language and said, oh, it seems cryptic or oblique, and so it's a major question, and we're not going to give it its plain meaning. In all of those cases, there was a textual and structural reason for the court to conclude that there was something wrong with the agency's claimed authority.
In all three cases, there were strong dissents that said the opposite of that, though, that said actually this statutory language is clear, and that the court, in Justice Marshall's dissent in the benzene case, is very powerful, that the court was simply scaling back from the plain language because of its concern about the significance of regulating every workplace in America to take out any risk of cancer. So there were dissents that made that point, but the majority seemed nonetheless to apply the major questions doctrine.
There were certainly dissents in those cases that thought that the statutory terms could get the agency there. But here, I think the critical difference is that the applicants haven't pointed to anything in this statute that approximates the kind of textual or structural problem that has prompted the court to look at those kinds of consequences before. And it would be their interpretation that creates those problems. They would render superfluous Section 669A5's specific recognition that immunization requirements can be imposed under the OSHA Act itself. By saying that OSHA can't regulate COVID-19 in the workplace, they give no effect to Congress's appropriation just last year directing OSHA to do just that and to target that grave danger. And so in this case, we think that all of the textual clues line up on our side in addition to the plain language of the statute.
And one other question related to this, sorry to prolong this, but Congress has specifically referred to vaccines in a variety of contexts. Immigration context, those statutes authorized specifically by language vaccines. Military context, which you would expect, at least the anthrax vaccine is referenced in the military statutes. The National Childhood Vaccine Act, passed in '86, refers, and that's a different context, but dealing with vaccines. And so that's one point. And the other is, since it forever, but 2005, President Bush gave a very detailed speech kind of predicting what has happened. And it's eerie to read it. And yet, in the years since, there has not been at least a vaccine statute passed by Congress to deal with this kind of thing, even though he, in the wake of 9/11, but still was putting the country on notice of this problem that was going to hit us at some point.
Well, I certainly recognize that there are other statutes where Congress has specifically referred to vaccination, and I think that maybe that would get applicants some traction here if, for example, this act specifically referred to other mitigation measures and illuminated what kinds of things OSHA could do and left vaccination off the list. But it doesn't do that. And so I think to suggest that there is some negative inference to be drawn is inconsistent with how Congress drafted this statute in recognition that OSHA would be positioned to understand the kinds of control measures that are necessary against the variety of workplace hazards. And if I could just make one additional point on that, of course, as I've emphasized, there is an express reference to immunization requirements in the OSHA Act itself. So we think that that actually provides additional confirmation that Congress was thinking about that and could have anticipated it, and that religious exemption would have no application if in fact immunization is just off limits. But I think as well, it's important to look at this against the backdrop of immunization requirements in our country. This is not some kind of newfangled thing. As I've mentioned before, most of us have been subject to compulsory vaccination requirements at various points throughout our lifetime. And so the idea that Congress couldn't have anticipated that in dealing with the deadliest virus that OSHA has experienced in its history, and might think that vaccination, encouragement of vaccination would be an appropriate way to protect workers, I think is just inconsistent with the idea that vaccination is often the single most effective way to target a virus.
Thank you.
Justice Barrett?
Two questions, both of which address the status of this rule as an emergency temporary standard. So my first question has to do with the question with which Justice Thomas opened, which is the meaning of necessary. So of course, when OSHA passes a rule through its regular regulatory process, it has to go through notice and comment. And that's a way of holding an agency accountable. All affected people have an opportunity to comment, and the agency develops a robust record. With an ETS, of course, the agency can circumvent that process so that it can act more quickly. So for an ETS, we would want that power to be the exception, not the rule. And one contrast that the applicants point out between OSHA's authority to issue an ETS versus a regular regulation is that for its exercise of power in the normal course, it need only find that a regulation be reasonably necessary, but for an ETS, it has to satisfy a necessary standard. Now, you've argued, and I think there's a lot of intuitive appeal to this, that when you're facing an emergency of the magnitude of this pandemic, that this power effectively can be used most effectively as a blunt instrument. You know, we don't have time to make industry by industry specific kind of calculations because we want to move with speed. But how do you reconcile that understanding of necessary with the broader reasonably necessary standard in OSHA's normal regulatory authority?
So we certainly agree that the emergency temporary standards reference to necessary as contrasted with reasonably necessary and appropriate is a heightened burden and includes a measure of tailoring that's necessary with respect to the particular mitigation measures. But I don't think that that helps the applicants here because they haven't come forward with any alternative mitigation measures that they think would equally protect the workers that OSHA found were in great danger.
But do they have to come forward with that evidence, or did OSHA have to consider it and reject it? Because another part of their contention is that OSHA did not adequately explain why this measure, this particular rule and its scope, was necessary vis-a-vis or as compared to other possibilities.
Well, OSHA explained that at length over dozens of pages in the 150-page preamble to the rule. OSHA specifically explained why vaccination as the single most effective way to target all of the ways that the virus threatens workers in the workplace was a necessary measure here, and it further explained why masking and testing would be essential if workers remain unvaccinated in order to ensure that despite their higher risk level of contracting the virus, they couldn't carry it into the workplace and spread it to their coworkers. So I think the suggestion that this wasn't adequately explained is inconsistent with the arguments they're making. And as I understand their tailoring arguments, and this actually touches on the question you asked earlier in the argument, they're really focused on two things: the categories of workers and the particular workplaces. And they haven't suggested that there are other mitigation measures there that OSHA neglected to consider. They're saying those things should have just been carved out altogether. But that is inconsistent with the Secretary's judgment that all unvaccinated workers face a grave danger and that the risk exists anywhere that employees are gathered indoors together. And again, there might be subcategories within those groups that are in graver danger, but I don't think there is any basis on this record to conclude that the agency lacked substantial evidence to draw the lines that it did.
That's helpful, thank you. My second question is, again, about the status of this rule as an ETS. So Chief Judge Sutton pointed out in his dissent from the denial of initial en banc that OSHA did not adopt this rule in response to the emergency, quiet emergency, because that had been ongoing since early 2020. But instead, it responded to new facts on the ground, which included the widespread availability of the vaccine that maybe it was a surprise many people chose to forego, and the emergence of the Delta variant. And Chief Judge Sutton pointed out that in an extended pandemic, or I don't know if we've moved to an endemic such as this one, facts will continually change. New variants will emerge. There might be new treatments, new vaccinations. We have boosters now, right? So now full vaccination might not just be the 2 jabs. It might include a booster as well. So when does the emergency end? I mean, a lot of this argument has been about Congress's failure to act. 2 years from now, do we have any reason to think that COVID will be gone or that new variants might not be emerging? And when must OSHA actually resort to its regular authority and go through notice and comment, and not simply be kind of doing it in this quick way, which doesn't afford people the voice in the process that they're otherwise entitled to?
So I think if I could respond to that in a few different ways. Congress defined when the emergency exists. It labeled this an emergency temporary standard, but it's dictated by the statutory requirements. So there has to be a grave danger from a physically harmful agent or a new hazard, and the measures have to be necessary to protect against that danger. And we don't think that there's an additional free-floating requirement about the emergency status that has to be taken into account.
So it could be an emergency 2 more years from now.
Well, I certainly take the point that the emergency can be of substantial duration. Of course, this is not a way to bypass notice and comment permanently. Congress further specified that the agency is expected to conduct a rulemaking process over 6 months, and that's why the agency estimated the lives saved, the hospitalizations prevented over the 6-month life of the rule.
Sure, but I was envisioning a new rule, right? Like, OSHA might 2 years from now adopt something that's different from this vaccine or mask and test mandate. I'm just talking about the limits more generally on OSHA's power under the ETS provision.
The limits, I think, are the ones written into the statute. And so if you want to project out 2 years from now, I think it's entirely possible, of course, that the trajectory of the pandemic will change. I certainly hope so. And in that case, OSHA, I think, would have to, if it wanted to regulate again, cross the high burden of showing a grave danger. This is an authority it has used sparingly in cases of what we think are true emergencies. And I think to suggest, based on concern about what might happen in the future, that its authority should be constrained or clipped now when we are in the middle of an unprecedented pandemic that is claiming more lives than we've seen in a shorter amount of time would do a disservice to Congress's anticipation that OSHA might need to act quickly in response to dangers like this. Thank you.
Mr. Keller, rebuttal?
Two points, Mr. Chief Justice. First, we need a stay now before enforcement starts. Our members have to submit publicly their plans to how to comply with this regulatory behemoth on Monday. Vaccines would need to occur by February 9th. You would need 2 vaccines to comply. Those vaccines would have to start immediately. Tracking and record keeping cannot happen overnight. And on tests, you heard my friend, the Solicitor General, mention the media reports that we've all seen about shortages of tests and cost increasing. Our declarations, appendix page 345 and 374 confirm that as well. And that's exactly why workers will quit right away. You don't even have to take our word for it. The federal government, the Postal Service, and Amtrak both say the same things. What OSHA did is they cherry-picked one study about healthcare workers, a very specific industry, and what that worker attrition rate would be. Again, 2 declaration sites, we have plenty more, but appendix pages 351 and 374. My second point to close on is about who decides in the public interest. And I would submit that this court's precedents answer that. We're not asking this court to reverse anything. Industrial Union 40 years ago, in Justice Stevens' controlling opinion, said that there was an absence of a clear mandate in the OSHA Act. So it's unreasonable to assume that Congress gave OSHA unprecedented power over American industry, and the emergency power is also narrowly circumscribed. Yet here OSHA has never before done mandated vaccines or widespread testing, much less over all industries or on an emergency basis. So whether we're talking about the agency's failure to explain, whether we're talking about the statutory term necessary, whether we're talking about how this has to be tethered to the workplace under the major questions doctrine, under any one of those theories, we are likely to succeed on the merits. And finally, when it comes to the public interest, as this court just recognized a few months ago, it is undisputable that the public has a strong interest in combating the spread of the COVID-19 Delta variant, but our system does not permit agencies to act unlawfully, even in pursuit of desirable ends. We would respectfully request a stay of this unprecedented sweeping ETS before Monday.
Sweeping ass.
Thank you, counsel. The applications are submitted.
All right. So, that is the end of the first hearing. Man, that girl could talk. I'm going to keep this live in the background. I'm just going to take it off screen here because there was no time for the second hearing. My guess is they're going to shuffle some paperwork and jump right into it. But the motor mouth, let me see if I can put this up. The motor mouth is this lady here. Wait till you see her eyes. I'm going to share this screen if I can get this here. Sorry, 1 second. Here she is. Share. That's her right there. That's the robot. That's crazy. She got those crazy eyes. But yeah, that's the lady who was talking very rapidly. Was she Solicitor General Elizabeth Prelogar? I saw a couple of comments related to comments that were getting deleted or censored, and one of them even said coward. I don't know if they meant that I was a coward or YouTube. I don't censor shit, which is why I just said that. YouTube has rules and for live streams and comments and stuff and things we can say or do. So my recommendation would be just be familiar with what their requirements are and follow it. Otherwise, they block them before I even get to see them. And Elizabeth Karen, yeah. So, all right. So they're asking for an emergency stay on this, and they want this before Monday, obviously. So they could rule today, Saturday, or Sunday. My guess is, I don't know. It's going to be a split decision. And typically the way the United States Supreme Court operates, let me just get this other screen back up here. Typically the way the United States Supreme Court operates in oral arguments that I've listened to or cases I've followed is that the side that they ask more questions of, there we go. Oh, here it is, right back at it. But they're typically the ones who lose. Here we go.
240, Biden, President of the United States versus Missouri, and the consolidated case. Mr. Fletcher.
Thank you, Mr. Chief Justice, and may it please the court. Hospitals, nursing homes, and other Medicare and Medicaid providers serve patients who are especially vulnerable to COVID-19 in settings that are especially conducive to the spread of the virus. The Secretary required those providers to make sure that their staff are vaccinated, subject to medical and religious exemptions, because he found that vaccination is the best way to prevent workers from infecting their patients with a potentially deadly disease. He also found that any delay in implementing that requirement would cause preventable deaths and severe illnesses. But the preliminary injunctions in these cases are delaying that urgently needed protection for Medicaid and Medicare patients in half the country. This court should stay those injunctions for 2 reasons. First, requiring medical staff vaccination during a pandemic falls squarely within the Secretary's statutory authority to protect the health and safety of Medicare and Medicaid patients. Vaccination requirements are a traditional and common way to curb the spread of infectious disease. Many healthcare workers are already required to be vaccinated against diseases like hepatitis, measles, and the flu. And the medical community overwhelmingly supports COVID-19 vaccination requirements, which have been adopted by providers around the country. Those requirements are, in short, the paradigmatic example of a health and safety measure. Second, the Secretary's decision was thoroughly explained and supported by the record. The states do not seriously deny that requiring vaccination will save lives. Instead, they predict that it will cause staffing shortages, especially in some rural areas. But the Secretary—
Can you guys hear him?
That concern. He explained that experience from around the country shows that most workers actually will choose to be vaccinated rather than to leave their jobs in response to vaccination requirements. That he concluded that the risk of some temporary staffing shortages is outweighed by the urgent need to protect all Medicare and Medicaid patients during a deadly pandemic. Congress assigned those quintessential predictive and policy judgments to the Secretary, and the states have identified no basis to disturb his conclusions. I'd welcome the court's questions.
He's kind of faint on this.
Counsel, are you relying on 1302A?
The Secretary invoked— that's the Secretary's general rulemaking authority under the Social Security Act, and he invoked that general rulemaking authority as he typically does when he makes rules under the Act. But we're not relying primarily or on that. We're instead relying on specific authorities as to each category of covered providers that allow the Secretary to set standards that set the requirements for their participation in Medicare and Medicaid.
I don't understand what you just said.
I'm sorry. The answer is yes, but not only on 1302. We also have specific statutes that speak to each of the covered providers here.
So if I look at the language in 1302, which says that the Secretary shall make and publish such rules and regulations as may be necessary to the efficient administration of the functions with which each is charged under this chapter. You say there is more than that authorizing the Secretary.
Correct, yes.
What is that more?
So the more is set forth. It's different as to each category of providers. So take hospitals. There, the additional authority is in section 1395X(E)(9), which authorizes the Secretary to set such requirements as he finds necessary in the interest of the health and safety of patients in Medicare and Medicaid. The Secretary cited other similar requirements that authorize him to set conditions of participation for each of the categories of providers, for nursing homes, for ambulatory surgical centers. All of those categories of providers are subject to similar requirements that say the Secretary gets to determine the requirements for their participation in Medicare and Medicaid. The Secretary has long relied on those specific statutory authorities to set forth detailed conditions of participation that are in the Code of Federal Regulations. And what he did here was say, I'm going to add an additional condition of participation pursuant to those specific authorities for each category of provider requiring vaccination against—
It's on their end, guys. You'd have to turn it up on your side.
Used in the past, the argument or the authority that you just set out, has that been used to require vaccinations in the past?
It has not, no. But the Secretary explained why not. He explained that this is a unique pandemic where we have unique access to effective vaccines. So he explained that in other settings, healthcare workers are typically vaccinated against communicable diseases because they got them during childhood when all of us did, or because state authorities have required vaccinations. But this is a uniquely deadly pandemic that, because it is so new, those requirements haven't caught up and ensured the level of staff vaccination that you see in the context of other diseases. And that's why he found it necessary to step in with this.
One last, just a question.
Thank you.
Don't you think it's a bit curious that you're placing significant reliance on a provision that speaks about necessary to the efficient administration to administer a vaccine that could have significant health consequences?
Justice Thomas, I don't. So first of all, I just want to be clear again, I'm not claiming that that general authority alone would authorize the vaccination requirement. We're resting on the conditions specific to each category provider, the vast majority of which, the ones covering 97% of the workers affected by this rule, specifically reference conditions aimed at health and safety.
Right.
I think when you look at it in that context, it's clear that this is a paradigmatic health and safety requirement.
Counsel, in which case is the relationship between the agency closer to the COVID-19 danger? In this CMS case that you're arguing before us now, or in the OSHA case that your boss just finished arguing?
I think they're different cases. I think it's hard to say which one is closer. The OSHA case, the OSHA Act gives the Secretary of Labor responsibility for workplace safety, and you just heard why the COVID-19 pandemic is a grave threat in the workplace. CMS has authority to protect the health and safety of patients in Medicare and Medicaid, and explained at length why the COVID-19 pandemic is an acute danger to patients in that setting. So I think they're both very close.
Well, maybe it expands it. Which is a more acute danger? OSHA, CMS, or the federal contractor vaccine mandate?
Well, I think all of them. I think this gets to the question you asked my boss earlier, which is, the government is doing a lot of things in response to the pandemic, and I don't think that's a surprise. This is an unprecedented pandemic that touches virtually every aspect of American life, and so it does affect the authorities of lots of different federal
Do you
agencies.
think the government has picked the three most pressing areas to address, and they're doing it in order? Or why OSHA, why CMS, why federal contractors, why not any host of other areas that are also, where COVID-19 is also a serious problem?
Well, because the federal government is, as some of the questions earlier had suggested, a government with limited powers. Federal agencies have the authorities that Congress has given them. Congress has made OSHA responsible for workplace safety. Congress has made CMS responsible for Medicaid and Medicare patient safety. And those agencies have determined and explained their conclusions why those authorities are called upon here by the sort of unique threat that the COVID-19 pandemic poses in both contexts.
I thought you might have said, and it may have been uncomfortable, but I thought you might have said we're dealing here in this case with healthcare, with Medicare and Medicaid. And what could be closer to addressing the COVID-19 problem to health than healthcare? I mean, people already get sick when they go to the hospital, but if they go and face COVID-19 concerns, well, that's much worse. On the other hand, OSHA, it's workplace. Yes, COVID is a problem in the workplace, and in some situations it may be a more serious problem. But it seems to me that if any of the three that I've been talking about anyway present a close connection, it would surely be between a health threat like COVID-19 and the government's health care.
Mr. Chief Justice, I certainly don't want to disagree with that at all. I think there is an acute threat that COVID-19 poses in healthcare settings. We've seen that throughout the pandemic, especially in nursing homes and other congregate care settings, which are within the scope of this rule. I absolutely agree that Americans shouldn't be forced to choose between getting medical care and exposing themselves unnecessarily to a virus. And as we explained, healthcare workers have long been expected to take extra precautions, including vaccinations, in order to prevent them from infecting their patients. So I don't disagree with any of that, but in making all of those points, I don't want to undersell also everything you heard about in the first case about the grave danger that the pandemic poses for workers as well, in a way that implicates OSHA's authority.
Counsel, there is another significant difference that you haven't talked about. This is a spending clause case and not a general powers case. And I always thought that when you're talking about spending clause, that the government has more power to define where it wants to spend its money, correct?
Absolutely.
And to that extent, one of the major arguments raised by the other side here that I want you to address is what they describe as the enormous cost that this will affect on hospitals and the fact that it's affecting so many healthcare providers, et cetera. Could you please tell me whether this is unprecedented in terms of what CMS generally does?
I can, and first, if I could, I'd like to put in context the cost. I think the Secretary's cost estimate was on the order of $1.3 billion, much of which will be borne by the federal government, which covers the cost of vaccinations. He put that in context by emphasizing that healthcare spending in this country is $4 trillion, and that the costs in this case amount to about $125 per employee. So I don't think the costs of this rule, when viewed in context, are particularly great. And I think that it is not at all unprecedented for the Secretary to exercise the same authorities that I was discussing with Justice Thomas here, the authorities to set conditions of participation for hospitals and other providers in Medicare and Medicaid, to impose very detailed, very prescriptive requirements that would have very high compliance costs. This is not a place where it's unfamiliar to have the Secretary involved in the details of the management of healthcare organizations.
Did the states have clear notice that by accepting Medicaid funds, they would be subject to vaccination requirements for staff at their state-run facilities?
So the facilities, and this applies to all facilities in Medicaid and Medicare, not to the states as the administrators of their own Medicaid programs, but I acknowledge states do have state-run facilities. All of them are on notice that they're subject to the health and safety requirements that the Secretary may adopt from time to time. Obviously, they didn't have specific notice of the vaccination requirement because it didn't exist until the pandemic came about, but the way that the program operates is that all providers are on notice that they have to comply with the Secretary's regulations, which could change.
So if they read the statutes that you are now relying on primarily, that would provide them clear notice that they might be subject to something like this vaccination requirement?
It would put them on clear notice that they are subject to such requirements as the Secretary finds necessary in the interests of patient health and safety, which have long included infection control. In the past, that's been general. It's been requiring infection control plans that meet national guidelines, fire preparedness, emergency safety, things of that nature. So they have long been on notice that they are subject to requirements by the Secretary in the interests of patient health and safety. And I think this is a sort of heartland case of a measure to protect patient health and safety in the midst of a pandemic.
I don't have before me the particular statutory provision that you spoke of earlier, but is it the case that some of many, if not all of these additional statutory provisions on which you are now placing your principal reliance are definitional provisions rather than provisions that expressly authorize the Secretary to promulgate regulations? Is that correct or incorrect?
They're both. So they are definitions. The provision I quoted earlier, 1395 SE, is the definition of a hospital for purposes of the statute.
Right.
But in that definition, it says a hospital, and what that means to be a hospital is to be eligible for Medicare reimbursement. What it means to be a hospital is to meet the following specified requirements, including such other requirements as the Secretary finds necessary. So,
but it doesn't say the Secretary is authorized to promulgate any regulations that protect the health and welfare of people in a hospital or in any of these other facilities. It says that the definition of a hospital and the definitions of these other facilities, by definition, they are facilities that are required to comply with regulations.
as the Secretary finds necessary in the interest of patient health and safety, yes.
Is there any limit to that power? But what could the Secretary, what if anything could the Secretary not do if the Secretary finds that something is necessary to protect the health and safety of people in those facilities?
Well, I think the major limit is the one in the text of the statute itself. The Secretary has to find that it's a requirement that's in the interests of patient health and safety, as the Secretary did here. I think the other constraints on that authority are the types of health and safety measures that you see in healthcare providers. So, and the way you know that this provision is within the Secretary's authority is that you see providers adopting it on their own. You see medical societies like the American Hospital Association, the AMA, the American Nurses Association recommending this policy. You see some states adopting this policy. I think all of those things are powerful confirmations that this is a routine, common, effective measure for protecting patient health and safety.
One of the arguments on the other side is that you were required by statute to consult with the states before you did this. What is your response to that?
There is a provision of the statute that says that when the Secretary sets conditions of participation for some of the providers at issue here, in carrying out that function, he shall consult with the states. The statute doesn't say that that consultation has to happen before rulemaking, and the way that the Secretary has long understood that to function is to require consultation in conjunction with the notice and comment process.
Isn't that an odd understanding of a consultation requirement? We're going to tell you to do something, and then after we've told you to do it, we're going to consult with you about what we've already said you have to do.
I don't think so, Justice Alito, in the context of the provisions of the statute that also contemplate, as the APA does, that in some circumstances the Secretary will have good cause to act without notice and comment. So in the ordinary case, there's going to be notice and public comment, which has the benefits that Justice Barrett referred to earlier. When that happens, you should also be sure you consult with the states and with accrediting boards. But when there's good cause to skip that, the agency has long interpreted that to mean that it can defer consultation with the states to the parallel public comment process.
Is there a good cause exception in the provision that requires consultation?
There isn't, but there's no temporal requirement at all. So it's actually the other side that's asking you to read into that a requirement that had happened before rulemaking and to make that requirement apply even when the good cause exception is satisfied. And we don't think there's any basis to do that, certainly not in the Secretary's past practice. This has long been the way that the Secretary has interpreted this provision in conjunction with the good cause exception to notice and comment.
Mr. Fletcher, can I follow up on the questions that Justice Thomas and Justice Alito have been asking you about the facility-specific statutes? I think it was wise to shift your focus to those because of their references to health and safety. But I find it difficult because the language of each of those statutes is different, and not all of them reference health and safety. So, for example, I think the one on long-term care facilities is your best, because that's the one that also refers to or requires skilled nursing facilities to establish and maintain an infection control program. That one, I think, gives you a stronger case than the ones that don't mention health and safety at all. Or, for example, for ambulatory surgical centers, the provision on which you rely describes the benefits provided to an individual, and then it lists the kind of services that would be covered, right? And then parenthetically, it says performed at an ambulatory surgical center, parentheses, that meets health and safety and other standards specified by the Secretary. It seems to me a heavier lift to say that that kind of aside in a parenthetical is a grant of authority to CMS to impose this kind of vaccination requirement on those who work at the ambulatory surgical center. So I guess my question is this. One, the government here seeking the stay of the injunction has the burden of showing likelihood of success on the merits. And I understand because of space limits and the number of statutes on which you're now relying, it would be hard to make the specific case for each of these provisions. But what if I think some of the provisions might support you and others don't? This was an omnibus rule, and even though the Secretary in a chart identified all these specific provisions, we don't really have before us the structural and textual arguments directed at each of these provisions. So what if I think some do and some don't? In an omnibus rule, what am I supposed to do?
Well, so we agree entirely that the focus ought to be on the statutory text, and one of our complaints with the district court decisions in these cases is that they blew past all of those distinctions and didn't focus on the text at all. So we absolutely agree the text of these provisions should be the court's focus. In terms of how to think about them, I understand it's unwieldy. There are 15 different provisions. I would group them into two categories. There are 11 or so that we cite at pages 5 to 6 of our reply brief that include that specific health and safety language in different formulations, but all of them specifically referring to requirements in the interests of patient health and safety. And as we've explained, we think that this is the paradigmatic health and safety regulation, and that's reinforced by the consensus of the medical community, by other regulators, by practices of providers. Now, there are a few statutes that we cite at page 9 of our reply brief that don't include that specific language. Those statutes are the ones applicable to providers that employ about 3% of all of the workers covered by the rule. Now, our view is that all of those statutes still give the Secretary the authority to set standards or requirements for participating providers. And if you look at those provisions, what you find is that Congress was a little bit less detailed. In the hospital provision of 1395(x)(e)(9), the preceding 8 sections all detail relatively nuanced, very specific requirements for hospitals. And then the E9 adds and such other requirements as may be necessary.
But what if I disagree? So I understand that your position is that all of these granted the Secretary authority. But what if I disagree? What if I say, for example, you suggested in a footnote in your reply brief that because such a small percentage of employees are covered by the statutes that don't reference health and safety, that we should just allow the injunction to remain in place only as to those. And let's say that I disagree with you that every single one of the statutes that references health and safety could be interpreted as a grant of rulemaking authority for the reason I suggested with ambulatory surgical centers. The rule is an omnibus rule. It wasn't adopted on a facility by facility basis. So if I assume the premise that I disagree with you that every single statute grants this authority, why shouldn't then we just leave the Fifth Circuit's injunction in place?
Well, because I think to the extent you're looking at likelihood of success, that's the factor that this would be relevant to. I think that does depend, as you say, on the authorities as to each category of providers. And the Secretary included, in some sense, it's an omnibus regulation. He did it all at once, but he included specific severability language that we cite in that footnote. It's at page 61,608 and said if any of these provisions are no good, then the rest ought to stand. And so I think if you disagree with us on either the provisions that lack health and safety language, or if you disagree with us on the ones that have it, although I want to talk about both of those things to hopefully persuade you otherwise, I think the result would be we don't have a likelihood of success at obtaining prevailing on those provisions. But that wouldn't justify allowing the injunctions to remain in place as to all of the other provisions, especially those that cover the vast majority of workers. So I think that's the approach we'd suggest if that's where you find yourself.
Mr. Fletcher, I do understand that we could go provision by provision, but I thought in reading your brief that the general authority to pass regulations with respect to the Secretary's functions, that all that you were saying is that generalized authority is well documented by the fact that in the vast majority of these, at least 11, if not 12, of these specific rules, they reference health and safety directly. Isn't that your point?
That's our point. And in addition, that even as to the ones that don't reference health and safety, so the end-stage renal disease providers or the psychiatric residential treatment facilities, those categories, Justice Barrett and Justice Sotomayor, they still give the Secretary even broader authority to set conditions for participation. And our view is that when the Secretary is authorized to set conditions for participation in Medicare and Medicaid, that has to include the authority to set patient health and safety requirements. And in fact, that's the way the Secretary has long interpreted them. If you look at the regulations that are being amended by the provisions addressing those categories of providers, they're existing bodies of patient health and safety measures, in many cases addressing infection control already, in other cases addressing other matters directed at patient health and safety. So the Secretary has long interpreted those more general grants of authority to include the authority to impose patient health and safety conditions, and we think that's the right way to read them in the context of the statute.
I dare say that I've looked at some of the regulations at issue here, not the ones you passed with respect to COVID, but the other regulations. Is it fair to say that the vast majority of the regulations across all facilities relate to health and safety?
I think that's fair, yes. That's certainly consistent with my reading of the regulations applicable to the facility providers at issue here.
It does seem that since it's a program to serve ill people with conditions like renal failure, psychiatric conditions, other conditions, that would be the primary focus of contracting with places that are safe for those people, correct?
Absolutely, and that's the way the Secretary has always understood those more general authorities.
Thank you.
If I could say just a word about the other argument that the other side has pressed heavily in this case, and that's the concern about staffing shortages. That is a concern that the Secretary acknowledged and considered in the regulation. And he explained nonetheless that he was adopting a vaccination requirement for several reasons. First, he explained that experience from around the country has shown that even workers who express hesitancy or even strong objections to becoming vaccinated don't actually end up leaving their jobs in those large numbers when vaccination requirements are imposed, when their employers can help facilitate vaccination, can counsel them, that across the economy, including in the healthcare sector, including in rural areas, including healthcare systems in North Carolina and Indiana, the Secretary found that vaccination requirements achieved very high levels of compliance. He sought comment on the issue. He sort of welcomed input from stakeholders about the particular challenges faced by rural hospitals. But he also explained that any temporary staffing shortages are likely to be relatively minor in the context of this industry, which already faces enormous staff turnover every year. He said the rate of staff turnover in the healthcare industry generally is about 25%. in normal conditions, and that in those circumstances, any marginal additional turnover attributable to the vaccination requirement does not outweigh the need to impose this health and safety measure that, again, is supported by the medical community and has already been adopted by providers around the country.
Thank you, counsel. Justice Thomas, Justice Breyer, anything further? Justice Alito? Justice Kagan?
Mr. Fletcher, the states talk quite a bit about the time that it took the administration to get out the good cause rule and suggest that in that amount of time, it could have done a full notice and comment proceeding. I guess I would like you to comment on that. Is that true?
It's not, for a number of reasons. I think the clearest is the provision governing notice and comment regulations that applies when good cause isn't found for the secretary. 1395HH says that the secretary has to allow a 60-day comment period. So that right there is more than 2 months. In addition to that, the secretary has to write the rule, which involves not just developing the regulation and fitting it into the existing conditions of participation for 15 different categories of providers, but also writing the sort of detailed cost-benefit analysis and Paperwork Reduction Act analysis that are required by statutes and executive orders and that occupy dozens of pages at the back end of the rule. So I think the suggestion that in 2 months the agency could have completed notice and comment rulemaking is inconsistent with both the applicable legal requirements and just experience with regulatory process more generally.
Yeah, I guess sort of for an ordinary person might say, well, if it's really important, why don't you just work faster?
I understand that. I mean, that doesn't get you around the 60-day time limit. And what I can tell you is that the secretary did work extremely fast, produced a 73-page rule in 2 months, and explained why the rule was necessary, satisfied all of the legal requirements. And I think, I don't want to fault my friends on the other side, but I think if the secretary had rushed something out with a less thorough explanation, I think we'd be hearing legal challenges that he hadn't adequately explained things or considered things or calculated out the cost benefits. I think agencies that are trying to make policies that will stick have to make sure that they engage in the kind of robust analysis and document that analysis in the way that the secretary did here.
Justice Sotomayor? Anything further? Back to you. Justice Gorsuch.
This statute, unlike the OSHA statute, actually contains an express limitation on the secretary's authority that we haven't yet discussed and that I know you're familiar with. Among other things, it says, the secretary shall not control the tenure of employees at covered healthcare facilities, or their compensation or their selection. And this regulation, arguably, the other side will say, I'm sure we're going to hear it, so I didn't want to hear you have a chance. It's going to say this effectively controls the employment of individuals at these healthcare facilities in a way that Congress specifically prohibited. As I understand your response, it is we're just providing money or not providing money. By withholding money, we're not controlling who you hire. And I might understand that in some circumstances, but in a statute where everything is about spending, it's a spending clause statute, I would have thought that Congress would have understood, and we should interpret this language in that light, that you cannot use the money as a weapon to control these things. And in fact, of course, as you know, the court has some anti-commandeering law that's doctrinal speak for you can't always use money without and claim you're not controlling what's going on. And I wonder whether we should take particular cognizance of that here, given that these statutes sometimes constitute, we're told, 10% of all the funding state governments receive. This regulation affects, we're told, 10 million healthcare workers and will cost over $1 billion for employers to comply with it. So what's your reaction to that? Why isn't this a regulation that effectively controls the employment and tenure of healthcare workers at hospitals, an issue Congress said the agency didn't have the authority? That should be left to the states to regulate.
So Justice Gorsuch, you're talking about Section 1395, and that says that nothing in the Medicaid Act shall be, or Medicare Act shall be interpreted to authorize any federal official to control, as you say, tenure, staffing, the practice of medicine, or the administration of entities. We read, as the secretary has long read, that to mean that he can't dictate particular decisions. Hire this person, don't hire that person, treat this patient this way, not that way. That's what control and supervision means. And
Can it mean though? Could it mean? Should it mean? Have we in other cases interpreted similar language to mean you can't use money in a way that commandeers a state or private entity?
So I think the most direct answer is that it can't mean that in this context, because you have to.
Could it mean it, and do you agree that it means that in other contexts?
Control and supervision can mean different things in different contexts, but I do want to get out that they have to mean something that's.
But fine, I'll let you do it, I promise. But you'd agree that in some contexts, in some circumstances, that's a possible meaning.
I think it may be a possible meaning. I don't think it's the most natural reading.
All right, and now you get to go ahead. Got it.
Thank you. I appreciate it. So the reason why it can't mean that here is that succeeding provisions of the Medicare statute authorize the secretary to do, or actually do directly by Congress, exactly that sort of standard setting that the secretary is engaged in here. So just take the hospital statute that we've talked about a bunch, 1396 XE. There's provision, we talked about E9, which is health and safety. The preceding provisions say things like you have to be staffed by doctors, and the doctors have to have particular licenses. You have to have a certified nurse on duty 24 hours a day. You have to have a budget plan that meets the requirements of another subsection.
Okay, so that doesn't control. But somewhere along the line, you move from general regulations that outline things you, the hospital, have to do, to somewhere more directly where you are controlling or supervising. We agree?
Yes.
There's a sliding scale in there.
I'm not sure about sliding scale. I would say standard setting, we can tell from that context.
There's a range. Can we agree on that?
Sure.
Okay. Where's the line?
I think that as often the case with ranges, the line may be hard to draw when you get out towards more granular controls. I think what I can be confident about is that this standard is on the right side of the line because it's consistent with standards in the statute itself that say you have to hire physicians and nurses that meet these qualifications, or with other provisions that say you have to train, your staff must be trained in this way.
I understand that. What do we do about the fact that Congress has never, the CMS, not Congress, we don't have Congress here. CMS has never before said among its standards a vaccination requirement or any other health standard with respect to employees and actions they must take outside the work environment. So, for example, could CMS also implement regulations about exercise regimes, sleep habits, medicines and supplements that must be ingested by hospital employees in the name of health and safety? And would the government argue that does not control the tenure of those employees?
I'm not sure that there'd be a problem with those requirements. I don't think it would be the Section 1395 control. I think it would be that it's very hard to characterize those as requirements for the health and safety of patients.
But in your view, that would not control the tenure of employees.
I think that does not. Setting standards, even if they're outlandish standards that we think couldn't be set for other reasons, wouldn't be controlled.
Still doesn't control. Doesn't control, even though they have to take these medications, they have to get this much sleep, they have to do this much exercise every day.
And anymore, again, I want to be clear. I'm not suggesting the secretary can do any of those things. I'm just suggesting that the reason he can't is not 1395.
Because it doesn't constitute control of an employee's tenure or compensation.
Correct, because setting standards for employees does not exercise control.
Justice Kavanaugh?
You mentioned at the beginning that the over $1 billion in costs would be borne mostly by the federal government, I think you said. Can you explain that?
Sure. I think in large part by the federal government. So the secretary, in estimating the cost, said a big driver of the cost was going to be the cost of the vaccinations themselves, the shots, and the cost of administering the shots. The secretary explained that he was including that in the cost-benefit analysis to be comprehensive about the effects of the rule, even though the federal government covers the costs of vaccines for most employees and would cover them here.
Okay. And then on the question, to follow up on Justice Gorsuch's question, what is the story, as you understand it, for why CMS has not previously required flu shots for healthcare workers or some of the other vaccines that, as you pointed out, the states still insist upon for healthcare workers? Is there a story there, explanation there for why CMS has not previously done that?
I think the secretary laid this out and sort of identified different reasons as to different categories of vaccines. So as to some where state vaccination requirements mean that everyone is basically vaccinated against those diseases already, there was no need for the secretary to do that. The secretary also hasn't acted with respect to flu vaccines. Some states have done that. Not every state has done that. But the secretary explained that this is a pandemic that is a much graver threat than the seasonal flu is, and also that these are uniquely effective vaccines, and explained that it's that combination, sort of unique pandemic situation that we haven't seen before, and uniquely effective vaccines that led him to choose to adopt that here.
Thank you.
Justice Barrett?
Are you arguing with respect to the facility-specific grants, and this goes back to the questions that Justice Sotomayor asked you after we last talked, are you arguing that those facility-specific grants inform the general grants in 1302A and 1395HH, such that we should interpret the general grants as encompassing the authority to impose health and safety measures? Or are you arguing that even if we pretend that these two general grants don't exist, that the facility-specific grants would nonetheless equip the secretary with this authority?
I think the latter. I think I'd be making the same argument even if we didn't have the general grant. I think the general grant, reinforces the idea that when the secretary sets standards, he has the power to do that through regulations, but we're relying primarily on the specific grants, and I think those would be sufficient even if you set aside 1302.
Thank you, counsel. Mr. Osete?
Mr. Chief Justice, and may it please the court. In early 2020, while millions stayed at home, millions of healthcare workers heroically stayed at work. These same workers are now forced to choose between losing their jobs and complying with the government's vaccine mandate. The Secretary's claim of authority to impose this mandate is expansive, unprecedented, and unlawful for two principal reasons. First, the Secretary believes a series of vague catch-all provisions scattered throughout the Social Security Act authorize the sweeping mandate, but the relevant text, structure, and context say otherwise. For example, the Secretary ignores 8 provisions that precede the catch-all provision he primarily invokes, all of which are materially unlike a permanent medical procedure that cannot be undone after a shift is over. Exceedingly clear language is required here because the mandate regulates matters that have traditionally been within the province of the states. Second, the rule is arbitrary and capricious under the APA. The Secretary impermissibly extrapolated evidence for one category of facilities to justify regulating all 15, and failed to adequately explain his sudden shift from encouraging vaccination to mandating it. But more fundamentally, the Secretary overlooked the critical perspective of rural healthcare facilities in the states and the devastating consequences the mandate will have on rural Americans' access to healthcare. Categorically excluding an entire class from employment will mean that patients in rural Nebraska will have to seek primary and emergency care 2 to 3 hours away and cannot undergo surgery. This represents vast stretches of this country where healthcare is not provided by massive institutional providers with tens of thousands of employees, but by smaller healthcare facilities run by local communities. While a 1% loss of staff may be insignificant to the former, it is fatal to the latter. Will face an imminent crisis. The government stay application should be denied, and I welcome the court's questions.
Counsel, would you discuss the preemption issue just briefly?
Yes, Your Honor. This regulation, the Secretary says in this regulation that it is intended to preempt arguably any inconsistent state laws with respect to vaccination requirements. And for example, in this case, the most direct example I can point to, Your Honor, is at 20-7-134 of the Arkansas Code that prohibits as a condition of employment any sort of vaccination requirement.
But that's somewhat ironic since the government relies on those other vaccinations to argue for this vaccination. But are all of the party states in the same position with respect to preemption?
Your Honor, certainly the district court in this case, at the very least, cited that Arkansas, Wyoming, and Missouri are similarly situated with that respect, and certainly there are other states in our the Missouri-led coalition that also have laws that are going to be preempted by this regulation. The key point here, Your Honor, just like in Mass VPA, is so long as one of us has one of these laws that would affect our duly enacted legislation through an unlawful mandate, it does present an issue on preemption. Now, that's independent, obviously, from other interests that the states have in this case, which is the states are the administrator. It's our providers with respect to Medicaid, with Medicare. We're being asked to facilitate this program for the federal government. We have compliance costs. We have surveyors who have to go out and enforce this rule. All of that are the state's interests, Your Honor.
Well, the one final point has to go to standing. You seem to rely on parens patriae a bit. And would you discuss that standing and why we should apply that?
Well, sure, Your Honor. And just to be clear, we do have various capacities here. We mentioned sovereign interest, we mentioned proprietary, a whole plethora of them. And certainly we did invoke also a quasi-sovereign interest in the health and well-being of our citizens. For example, this mandate will close the doors of many of these rural facilities that will effectively deprive our citizens of healthcare. And we also are asserting rights under federal law with respect to the APA on many of these claims. But that is not the only basis that we're seeking standing in this case. We have various other capacities that we're suing under, just like the ones I mentioned, Your Honor.
Is that true of all of the parties?
I believe so, Your Honor, yes.
Thank you.
There was a question, sorry, Chief.
No, I was just going to ask you about the spending clause context. In other words, we're not just dealing with federal law in the abstract, we're dealing with a provision that says Congress authorized the Secretary to ensure compliance with requirements that the Secretary finds necessary in the interest of the health and safety of patients. That's very broad, and I think, will you agree that they have broader authority because it's in a spending clause provision? I mean, you signed the contract.
Well, sure. And even in the spending clause, I would say two responses to that, Your Honor. First, even in the spending clause context, as Justice Alito mentioned earlier, the states are entitled to clear notice. So there is, whatever conditions the Secretary does state, they have to derive from unambiguous grants of statutory authority. In this case, Your Honor, we respectfully disagree with my friend, Mr. Fletcher, because he only cites certain parts of these provisions. For example, with respect to the hospital in this application, he ignores the such other requirements language that precedes the Secretary's authority to regulate health and safety. And many of those provisions, for example, E1 through 8, none of those talk about immunization. They talk about record keeping. They talk about discharge procedures. They talk about
Mr. Rossetti, really, do you think that the CMS head and that the Secretary of HHS are bookkeepers with respect to this statute? Do you think that they don't have responsibility to protect the safety of these two incredibly vulnerable patient populations? Isn't that their principal responsibility in these laws? Isn't that the most important thing that both of them do?
Your Honor, certainly the Secretary does have authority to set requirements in the interest of health and safety. All I'm saying is you have to look at the statute in context. And I'm not saying that HHS is somehow just this record-keeping function. I mean, certainly it is important for these facilities to have adequate record-keeping. You're dealing with vital records, health records, other things.
I wasn't saying that they don't have to be concerned about records either. I'm just saying, in addition to being concerned about records, this statute clearly gives them, by reference to the health and safety delegations, by reference even to the idea of administering efficiently programs like this, their principal job is to look after the health and safety of Medicare and Medicaid recipients. And with the understanding that those two groups of patients are pretty much the most vulnerable patients there are, either elderly patients or in the case of Medicaid, unfortunately, poverty has a great deal to do with medical outcomes. So, with respect to these two vulnerable populations, and especially vulnerable when it comes to COVID, how can it not be the principal prime responsibility of the CMS head and the Secretary of HHS to look out for their health and safety?
Because that responsibility that falls in E9 with respect to the hospitals, which is what the Secretary has put forward in this application, that authority is informed, the grant of authority in that section is informed by the other provisions in that statute. Doubly so here, Your Honor, where you have a situation where this court has said that ordinarily compulsory vaccination is not something that ordinarily concerns the federal government. That was in Jacobson at page 38. Doubly so here, Your Honor, because when you're going to significantly alter the balance between state and federal power, something that has traditionally been in the province and the states, you have to do so with exceedingly clear language. The court said that in Alabama Realtors recently. The court said that also in U.S. Forest in 2020. That is the kind of language we're asking here. It's not that the secretary.
Do you think that the secretary can require the adoption of various infection prevention and control measures? You know, can they say to hospitals, you have to sterilize your instruments, you have to wash your hands in a certain way? One of the things we understand about settings like this one is the way that infections spread. And you have to do a variety of things to make sure that you prevent the spread of infection. Can they do that?
Absolutely.
Because that's their job, right?
Your Honor, certainly with respect to 1395 I-3D3, which goes to skilled nursing facilities, there's express language that the secretary can adopt infection control measures to prevent the spread.
Whether there's express language of that kind or not, the responsibility to look after the health and safety of vulnerable populations includes requiring infection prevention and measures. Isn't that right?
Well, certainly, Your Honor, if Congress decided to write statutes in very express terms with respect to the skilled nursing facilities, and I will submit.
I think you're ignoring the question. Put that aside. Suppose it didn't say infection at all, but it says you have to look after the health and safety of your patients. Does that include infection prevention?
It may very well include infection prevention. I guess all I'm saying is that in this case, Your Honor, where there is express language that talks about that, Congress knows how to do that and chose not to regulate with such specificity.
Your view is what you're saying is they don't have authority to do this. Is that in response to Justice Kagan?
Your Honor,
they can't say wash your hands. Can they say if there's a diphtheria academic, we don't want anybody with diphtheria walking into the hospital because everybody will get it. You're saying they can't say that. Is that right?
Your Honor, there are various measures.
Well, are you saying that or not? Take the example that Justice Kagan gave of the washing hands or sterilizing instruments, or the one I just gave you of diphtheria. Can they say it or not?
Yes, they can regulate.
All right, if they can say that, then why can't they say the same breath, and by the way, we don't want you walking in here in crowds that will spread COVID, and this is how you stop it. Why can they say the one and not the other?
Because gloves, taking off gloves and masks, a vaccine cannot.
I didn't say that. I said diphtheria.
Your Honor, the Secretary certainly has authority to implement all kinds of infection control measures at these facilities. No, I'm not disputing that, Your Honor.
Well, all the Secretary is doing here is to say to providers, you know what, like basically the one thing you can't do is to kill your patients. So you have to get vaccinated so that you're not transmitting the disease that can kill elderly Medicare patients, that can kill sick Medicaid patients. I mean, that seems like a pretty basic infection prevention measure. You can't be the carrier of disease.
But Your Honor, here we're dealing specifically with a vaccine requirement that again has historically been in the state's province. And if Congress wants to give that authority to CMS, the federal agency here, it has to do so in exceedingly clear language.
Or what do I do with this if you want to be real? Perhaps you could tell me I'm way off base, and I don't mind if you do. But I mean, here we are, asked for a stay. Okay?
Mm-hmm.
And in the one case, either this will go ahead or it won't. One case earlier, it'll go ahead or it won't. And to what extent can we take account of what I think would be relevant with stays or not stays or how we act in the interim, Okay? That there are 750,000 people got this yesterday. That the hospitals are full to overflowing. That there is a problem worse than diphtheria. The people all over the world are getting this, and they are here too, and they're dying. That's what we're trying to ask you. Or they're filling up hospital beds and others are dying because they can't get in. Okay? Now, public interest, call it something else, call it what you might. But it seems to me, it's hard for me to believe, but it seems to me that every minute that these things are not in effect, thousands of more people are getting this disease, okay? And we have some discretionary power. And therefore, Will you tell me I can't take that into account? To me, that's fairly unbelievable, but I want to hear it.
Your Honor, the public interest is flexible, and you can take all that account. All I'm saying is the two statutes, the provision that the Secretary has put forward in this case, we do not believe that they have met their burden of showing a likelihood of success, that on the merits, those were lawful exercises of authority. Even in situations where the Secretary desires to prevent the spread of COVID, it cannot act unlawfully. Doubly so here again, because this is exactly the kind of requirement that historically has been in the province of the states. And if Congress wants to take that away and give it to CMS or give it to a federal agency, it has to do so in exceedingly clear. Now, I will point out too, in the public interest, Your Honor, doing away with the injunction, as we said so, is going to be devastating to vulnerable patients in rural America, in rural Nebraska. No surgeries. The only anesthesiologist in a rural Nebraska hospital, he is not going to be able to go to work. That means no surgeries. Emergency C-sections.
But I have on that one, I have a question too. I take what you say is correct. All right. I don't know if it is correct, but I'll assume it. Well, if these states, if we act in such a way that over the next 2 weeks or the next week, these rules go ahead as planned, and people do get inoculated because they have to, or now, if the bad thing that you are talking about then occurs, we'll know it. Because what they're saying at the moment on the other side is there is another bad thing, which is the bad thing that I mentioned at the beginning, that hundreds of thousands of people more get this disease. And we know what happens from Massachusetts and in New York, in the old people's homes. Okay? So they're saying there are two bad things. And you're saying the one and the agency, the other, is the more predominant. So suppose if faced with that division, we let it go ahead. And then if you're right, everybody will know it. And we can draw back. That's not perfect for you. But that's at least something, and it helps protect the people who might otherwise get very sick.
And unfortunately, Your Honor, it's going to, Mr. Chief Justice,
Yeah, please.
unfortunately, Your Honor, in this case, it's going to devastate local economies. It's going to decimate these local towns that don't draw their pool of applicants from the coast, Your Honor. These are local communities. They run these hospitals. And that is the problem here, Your Honor, is those kind of interests, that perspective was not heard in this context. And that is going to be devastating, Your Honor.
Justice Thomas, anything further? All right, no? Justice Alito? Justice Kagan?
Mr. Rossetti, this rural hospital question, you've presented some declarations that suggest that there would be labor disruptions. The Secretary took that into account specifically. Basically has a different view of the size of the disruptions based on the data that he had. And then in addition to that, said that there are countervailing things. There's countervailing things with respect to the labor force. And the Secretary says some people might come back because they won't have to deal with unvaccinated colleagues. That there will be savings in terms of fewer people out sick and so forth. And then the Secretary has an important job to do, and that's to balance whatever disruptions there are. The Secretary says they're much less than you say they are, but then to balance those disruptions against the safety of the Medicare and Medicaid recipients whom he is statutorily obligated to protect. And you know, it just seems pretty basic to me, as I said, that the first thing that means in the context of this pandemic is that providers can't be carriers of the disease itself. And then in addition, there are other health benefits. You know, people are not showing up to hospitals because they're afraid of getting COVID from staff. And so they're not coming for their mammograms and they're not coming for their colonoscopies and so forth. So he has to balance all those health benefits against what you say are these labor disruptions. And the question is, I mean, you might have a point. I don't know. I don't know very much about the rural market, you know, but the Secretary, that's his job. Should it be that we decide, you know, as against what the Secretary has decided in performing his important function of evaluating these potential disruptions and weighing those disruptions against the health benefits that he sees in that rule. Should we say we think that the disruptions are more greater than the secretary thought, and we further would weigh them differently against the health benefits of the rule? Is that for courts to decide?
Your Honor, there is a lot there, and I think the simplest way I can answer that directly is, in this case, it's this critical perspective of these tiny communities that, again, he did cite to one example in North Carolina with 35,000, I think it was Novant Health, 35,000 employees, as this is not going to be insignificant to them. But I think that critical perspective of these tiny hospitals that, again, are 100 or less, these numerous facilities that are going to be devastated by this, that sort of relevant factor, that important aspect of the problem, we don't see how the secretary could have properly weighed everything properly when that sort of critical perspective was ignored. And these folks did not have a chance to be heard. And in this case, it's almost as if the secretary put a rock on one side of the scale and a feather on the other. What may work in Detroit and Houston may actually be counterproductive in Memphis, Missouri, or for that matter, in El Dorado, Arkansas. All of those places have different considerations, which is why this historically has been a local and state matter. And the states, again, are free to require it or not require it.
So why is this an issue for the states to require or not require? I mean, this is the federal government paying for services. And why doesn't it have a right as the payer for services to specify what services it wants to pay for? I mean, that's, now, in terms of clear rules, I'm having a very hard time understanding how you can say, yes, they could pass a rule that requires people to wear gloves, or they could pass a rule that requires them to isolate individuals who are infected by something. But they can't pass this rule, and you say because it wasn't clear? If it's clear enough that they can consider safety and health regulations, why is this particular rule subject to us saying no?
Because, Your Honor, this court in Jacobson in various cases has drawn the line at compulsory vaccination being something that the states do. And when Congress...
Wait a minute, that's what they do with respect to other issues, but this is with respect to, if you want my money, your facility has to do this.
Sure.
It has to have, it has to serve certain food. It has to serve certain meals a day. It has to give snacks. These are all state issues usually, but under the spending clause, we're the buyer. The federal government says what it wants to spend its money on. This is not an issue of power between the states and federal government. This is an issue of what right does the federal government to dictate what it wants to buy?
Your Honor, it is a vaccine requirement masquerading as a condition of participation. And if Congress intended that, this court has made it very clear that something like compulsory vaccination, even in the spending clause context, which itself demands Congress to speak with a clear voice, it requires...
How much clearer do you need for Congress to say then pass regulations that protect the health and welfare of ill people?
Perhaps the one example I can think of right away, Your Honor, is in E7 of 1395-XE, where Congress acknowledged or spoke with a very clear voice that when it comes to licensing at the state level, that is something that the states do. And that's exactly, I mean, Congress knows how to directly speak to issues that invade into state areas.
And it hasn't done it with health and safety. It has given that right to the commissioner. Thank you, counsel.
Justice Kavanaugh?
A couple questions. First, this is an unusual administrative law situation from my experience because the people who are regulated are not here complaining about the regulation. The hospitals and healthcare organizations, it's a very unusual situation. They, in fact, overwhelmingly appear to support the Secretary's the CMS regulation. So and the government makes something of that. What are we to make of that?
Your Honor, certainly there are large institutional providers that may have no problem with this. Obviously, there are smaller ones, very small community hospitals that do have a problem with that. But here, the states have their facilities. The
states have a very small percentage of the facilities. Most of the facilities are private-run facilities, right? This picks up on Justice Thomas's question, like where are the regulated parties complaining about the regulation? That's how we usually have. The last case is a good example, obviously. There's a missing element here.
Well, they're not certainly these sort of entities that would be subject to this rule, like small private facilities that receive Medicaid funding, certainly are not plaintiffs per se, but the states do represent the citizens of our constituencies, like these places that run these facilities, these small community hospitals. We speak on their behalves. And all I would say here is we have made value judgments through our policies to not require vaccination because a one-size-fits-all requirement does not help. And that kind of policy judgment, as expressed through our laws, our duly enacted laws that would be applicable both to state-run facilities and private facilities, that is just what's being preempted here, Your Honor, by this unlawful mandate. And that's how we're speaking in that capacity here, Your Honor, is the folks whose voices were ignored throughout this entire process and shouldn't have been ignored, especially with these devastating consequences.
And then second, I think you've alluded to this, but how is a vaccine different in kind from your perspective from, say, the requirement to wear gloves or the requirement to wash your hands or the other kinds of requirements? Because I think if you acknowledge that there's authority to require the latter, then you need to explain why the vaccine's different.
I don't think I could say it any better than Chief Judge Sutton did at page 12 of his dissent in the OSHA case, which is masks can come off, gloves can come off. A vaccine requirement, the taking a vaccine is a permanent medical procedure that cannot come off after work is over.
Mm-hmm.
That is, there are materially different conditions, materially different procedures at stake. And when you look at the context, for example, in the hospital requirement, 1395 XE, nothing in that statute comes close to authorizing this precise mandate in this case, which is going to have devastating consequences for vast swaths of this country, Your Honor.
Thank you very much.
Justice Barrett?
Questions?
Thank you, counsel. General Murrell, are you still on the line?
I am, Mr. Chief Justice.
You may proceed.
Thank you, Mr. Chief Justice, and may it please the court. This case is not about whether vaccines are effective, useful, or a good idea. It's about whether this federal executive branch agency has the power to force millions of people working for or with a Medicare or Medicaid provider to undergo an invasive, irrevocable, forced medical treatment, a COVID shot. It's a bureaucratic power move that is unprecedented. If it can do that, the question still remains as to whether it properly exercised that power here. The district court answered no to both questions at the preliminary injunction stage, and the court below supported its ruling with a number of well-reasoned conclusions. Now, without even addressing all the underlying bases for the ruling, the government asked this court to jump ahead of the Fifth Circuit and dissolve the injunction, irrevocably changing the status quo in a way that will effectively give the federal government all the relief it seeks. This will create chaos in state provider networks, limit access to care for the poor and needy, and eviscerate informed consent for millions of people. The court should reject the government's request and maintain the status quo because the district court's holdings were correct on all counts. I'm happy to take questions or speak to some of the questions that have already been asked by the court.
Just briefly, counsel, I'd like you to address whether or not, or at least to what extent, this rule preempts rules of your state.
Justice Thomas, it does preempt rules of some of the states in our coalition. I don't know that it preempts rules in every state, but it affects Alabama, Louisiana, and Montana in different ways, different laws.
Could you address, as I asked earlier, the parens patriae standing, I think that's going to be an important matter, and I'd like you to address it.
So I think we have parents patriae standing to protect the interests of our citizens, but that is not the sole basis on which we appear in these cases. And there's been, some questions about Medicare and Medicaid. I think the government has conflated those two programs in an enormous way, because just in Louisiana alone, I can tell you that 41% of our budget is Medicaid funding. So we have enormous interest in the way these programs operate, and that's one of the reasons why there are express consultation requirements built into the statute.
Thank you.
General, do you agree with the district court's statement that COVID, just a quote, COVID no longer poses the dire emergency it once did?
Your Honor, I think that is those are shifting sands. Obviously, COVID conditions can change at any given time, and they have.
But what is your other basis for standing?
Our basis for standing is that we are being regulated directly by this rule. We have to implement it, and it affects our provider network. It directly affects Medicaid funding, and that is a program that is implemented entirely by the state. I don't think I could underestimate enough the impact on the states and their provider networks. That's precisely what the declarations that we submitted, and I think many that were submitted in the Missouri case also go to the effect on our ability to actually provide access to care, which is the actual primary goal of this program.
I'd like to touch on the spending clause issue just a bit. It was a broad provision that you agreed to, which authorized the secretary to impose requirements that the secretary finds are necessary in the interest of the health and safety of patients. Why did that not give you adequate notice that something like this could be enacted?
I don't think that gave us any more notice that could be enacted than, no one even expected COVID. So how could we possibly have expected to have the federal government, through a spending condition imposed upon us years after this program was created, co-opt a quintessential state police power for deciding whether its citizens should be vaccinated or not? That's just not something that we could have reasonably anticipated, given the general broad language that is put into the statute. And again, I don't think that their primary role is to actually provide directly for the health and safety of the people. It is to provide funding to the state to implement these programs, or through Medicare to reimburse for health care to individuals. I would also point just to the secondary aspect of any spending clause argument also turns on the voluntarily and knowingly accepting the terms. And so I think that goes straight to your question, that respecting that limitation is absolutely critical to respecting the balance of the state's sovereignty in this program.
How does that determination, it is what the secretary finds, and it's what the secretary finds necessary. So I'm not saying there's not some limit there, but I don't know why a provision addressing an infectious disease of this scope is beyond the secretary's determination that the mandated issue here is necessary.
Well, we've never taken the position that the secretary has no authority to address it in any at all. We're saying that they can't do this.
and they've never, ever, ever done anything like this, which they acknowledge. And the Solicitor General, in the argument that preceded this one, also pointed and conceded that where there are other textual and structural cues in a statute that may be inconsistent with the agency's jurisdiction, that you should be looking at that in terms of the discretion that you give, and whether, when you evaluate whether this is a question or an issue that falls within the general discretion and scope that was granted earlier by Congress. And here there are multiple cues that conflict directly with the broad scope and grant of authorities that they're claiming here.
Crickets.
Do you think we need to find that you have parents patriae standing in order to take into account the interests of employees within your state who do not want to be vaccinated? Is that a standing question, or is it a question that can be taken into account in the context of determining what the statute means and whether it satisfies whatever requirements there may be under the spending clause?
I think it's both. I mean, I certainly believe that you can take it into account as part of our standing. We have independent grounds for standing. When you get past that question, I think it also relates to the question of whether it's actually controlling the tenure of employees. I think it directly conflicts with that. I mean, Justice Alito, there's really no question, I think, in our mind that this was a pretext, that the entire, as the Chief Justice alluded to, that this was a workaround. This was an intent that the government intended to tether all of these restrictions together, all of these mandates together to vaccinate as much of the American public as they could touch. And in this particular rule at the Federal Register 61607, that the government even acknowledged that the most important inducement here was the fear of job loss. This is targeted at people. It's not targeted at facilities. And they've never done anything like this before, precisely because there are structural prohibitions against it in the statute. And where we are in this procedure is extraordinary. They want you to dissolve an injunction, parts of which have not even been contested, so that they can upend the status quo, which will disturb enormously our provider network.
Well, all that's true, but I'd like to get your response. I mean, there's some truth to what you say, but I'd like to get your response to what I asked previously twice, really. We set in both these cases something as the inheritor of a court of equity. And we do that particularly in respect to stays, whether you call them administrative or not. That may be both sides, and in the other case, that's why I say the side in each case that is predicting harm if the agency rule goes into effect. And the other side predicts serious harm if the agency rule does not go into effect. And as you heard in the OSHA case at the last minute, on the one hand, if they have to start complying with this, they have to get plans and the employers are hurt. On the other hand, if they don't start to get those plans ready, looks like a lot of people will get sick and take up hospital beds or worse. So in weighing those equities, why don't we have to take and put quite a lot of weight on avoiding even by a minute or a second? Because if you divide 750,000 by the number of seconds in a day, you get a lot of people. And why do we not have to take those things into account, see how the government would balance them, see if that is reasonable, and be very wary at the least of interfering with rules that will, in fact, save people's lives or hospital beds or from getting the disease? You see what I am saying? I'm asking. I'm putting a burden on you to say, yeah, that's what I am.
I do.
I wanna know
I understand the question.
Yeah.
I think first of all, these aren't just plans. Here, this rule is different. There's no test and mask exception. This is a vaccinate, and it's a short shot clock. And so they do not have a choice. They have to be fired or they cannot be hired. And so it handcuffs our providers in a way that is extraordinary and immediate. And the status quo right now is that they still comply with all the other rules of Medicaid and Medicare, which means they have infectious disease control measures in place. They are doing the very best job that they can. They need all the boots on the ground that they can get. And this rule will actually change that. It will immediately change that. So I think it is extraordinarily different. And it also comes up in a different context. It comes up in the context of a preliminary injunction, multiple injunctions, but specifically in ours, where they did not even contest certain aspects of it. So they present to you a request for a stay that does not even contest certain aspects of an injunction that they want you to overturn.
Thank you.
Counsel, I'm having a very hard time trying to do this state power argument with respect to a standing clause program that doesn't affect the states directly, except as proprietors. Because as proprietor of state-run facilities, those are the ones that are affected by this rule. The private facilities are, and as one of my colleagues noted, Justice Kavanaugh, we don't have many amici of them complaining. But putting that aside, I am having a hard time understanding how and why a rule like this is so substantially different than the volumes of rules that CMS has with respect to so many issues involving health and welfare. They tell you how high the bed has to be. They tell you how close hand sanitizers have to be. This is before COVID. They have so many different rules that one could arguably say belonged within the state's rights that give me a working principle that says to the federal agency charged with the health and safety of patients, who believes that the only way to protect these vulnerable patients is by this one tactic, by this one step, why that should tie their hands. You may argue otherwise, that the other ways of doing it are effective, but they've decided in this particular context, with the vulnerability of these particular populations, that the other steps are inadequate.
Your Honor, there's two aspects to your question, and I'd like to speak to both of them. One is the issue of whether we're just proprietors. We're not just proprietors. And I think the court effectively discussed that in NFIB versus Sebelius. Medicaid is an enormous program where states are contracted with the federal government, not providers. The providers are contracted with the states. So it is important, I think, to keep that distinction between these two programs. To your question about the dividing line, the dividing line here is precisely why we are in a major questions doctrine land, because they have never done this for at least since the Jacobson case. And before that, predominantly, this has been a question of protecting the health and safety of individuals, and exercising this kind of power to force the individual to submit to a medical treatment has never, ever been something that has been authorized by Congress or done by an agency on an emergency basis.
Counsel, I don't mean to interrupt you, but we've never had a situation like this one before. It's unprecedented
But I don't think in this case that justifies them co-opting a quintessential state police power. In fact, the opposite is true. It only points up the need to evaluate this in the larger context of whether Congress didn't do this, by the way. I mean, the Congress, just as recently as last summer, changed some of the discrete statutes specifically related to skilled nursing and nursing homes and authorized certain measures for strike teams to augment staff in those facilities due to COVID outbreaks, but they didn't authorize vaccines. So for staff, I think there are cues. There are cues in the statute. There are cues in the history and structure and the precedents of this court that support waiting and maintaining the status quo as the district court below did and the Fifth Circuit did.
Justice Thomas, anything further? Justice Breyer? Justice Alito? Anything further, Justice Sotomayor?
I just want to say the Sixth Circuit didn't, correct?
The Sixth Circuit in the OSHA case
I'm sorry. I think
operated differently.
Yes.
Yes.
Justice Kagan? Justice Gorsuch? Kavanaugh? Justice Barrett? Thank you, counsel. Rebuttal, Mr. Fletcher?
Thank you, Mr. Chief Justice. Just 3 quick points. I'd like to start with the interpretation of the statutes before you that the other side is offering, because I don't hear them to contest that the Secretary's authority to set conditions for participating in the federal Medicare and Medicaid programs includes the authority to protect patient health and safety, even in the statutes that don't include that language. I don't hear them to be disputing that the Secretary can adopt infection control mechanisms or require people to wear gloves or do other things of that nature. Instead, their submission seems to be that vaccines are different. And I think the problem with that is that they haven't really given you a basis to ground that in the statute. The first thing that they've said is vaccination is typically the prerogative of the states. And of course, that's true in some sense, but we're talking here about a federal spending program. And the regulation of medicine is typically the prerogative of the states. Usually it's the states who require hospitals to make sure their employees wear gloves or they follow the fire code or they have sprinklers, things like that. But no one disputes that Congress has given the Secretary the authority to make sure that providers who are providing care under the aegis of the federal Medicare and Medicaid program live up to standards set by the Secretary. That's what the Secretary has done here. The other thing that I've heard them say about why vaccines are different is that you can't take them off, that vaccines are somehow different than gloves or other safety measures, and so some special specific authorization ought to be required. And I just don't think that can be squared with the context of the healthcare industry. Vaccination requirements are common throughout our society. They're particularly common for healthcare workers. They've been adopted voluntarily by providers around the country. You have virtually the uniform view of the medical community telling you that this is the best way to protect patient health and safety. If anything, I think it would be bizarre to say that the Secretary's authority to protect the health and safety of Medicare and Medicaid patients does not include the authority to adopt a measure that you see other regulators adopting, the medical community urging, and other providers adopting voluntarily. The whole point of the statute is to let the Secretary make sure that the standards of care for medical care and Medicaid patients meet best practices, and that's what he's done here. The second point I want to make, Justice Barrett, goes back to the colloquy that you and I had earlier about some of the different statutes. I hope we persuaded you that we're right about all of them, but in case we have not, I just want to make the case that it actually is worth the candle in this stay posture to go provision by provision. So as we explained, 97% of the employees affected by this regulation are covered by statutes that include the express health and safety language. Even if you just narrow it down beyond that, 3 categories, the largest 3 categories of providers, hospitals, home health agencies, and long-term care facilities, account for more than 90% of the covered workers. This is shown at the table at page 61,603. All of those provisions have express health and safety language of the sort that we've been discussing, and 2 of them, long-term care facilities or nursing homes and home health providers, actually include the extra provisions that we cite at page 6 of our reply that says the Secretary has not just the authority to ensure health and safety, but also the duty to do so. I think at an absolute minimum, it's worth letting the rule go into effect as to them. And finally, Justice Breyer, I want to come back to a point that you've raised a few times about the equities because we are here on a stay. And I think a couple of observations to make about the equities. The first is a point that Justice Kavanaugh raised. You don't have providers before you here. You don't have workers before you here. Instead, providers and workers overwhelmingly support the vaccination requirement. Instead, you have before you states who do operate some facilities covered by the rule, but only a tiny fraction of them. The second thing I'd say is that even as to the providers and the workers who are covered by the regulation, some of my friends' presentation has suggested that if the stays are lifted, or if the preliminary injunctions are stayed and the rule goes into effect, that means that tomorrow people are going to be out of a job. And that is not true. The Secretary has put out guidance after the Fifth Circuit narrowed the previously nationwide injunction to cover only the plaintiff states here, put out guidance giving regulated entities 30 days to come into compliance as to the first shot, 60 days to come into the compliance as to the second shot, and making clear that even if a regulated entity has not met full compliance by that 60-day deadline, if the entity is at 90% compliance and has a plan to come into full compliance within 30 days, the Secretary won't take enforcement action. Even if that isn't met, even if at the end of 90 days there's still not full compliance, the Secretary has always exercised enforcement discretion before terminating a provider from the program. And one of the things the Secretary has considered is access to care issues, the sort that the other side has raised. So there are ways to address some of the problems that my friends have relied on, even if the rule goes into effect. On the other side of the ledger, and this is where I'll close, if the preliminary injunctions remain stayed, then we know what the consequence is. We know that this urgently needed measure is not going to be in effect to protect Medicare and Medicaid patients in half of the country during a pandemic. And I think the Secretary found, and I don't think anyone seriously disputes, that any delay in the operation of the rule will cost lives and cause unnecessary serious illnesses. We'd ask that the preliminary injunctions be stayed.
Thank you, counsel. The applications are submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
All right, that's a wrap. Let me try to adjust my stuff again. If my microphone gets all wonky, let me know. Woo! What a day! 4 hours of listening to that is making my my soul hurts. Thank goodness for Miss Elizabeth Morrill from Baton Rouge, Louisiana, the Solicitor General. I don't even know what I don't know. We'll see. They're both cases are asking for an emergency stay, and the implementations from OSHA start Monday, which is when the court is in recess until. So they'll have to make a decision. They're going to put it out today or over the weekend. So if you want to know what happens with these two stays that are being requested, subscribe to Guns and Gadgets. I'll let you know as soon as it comes down. And thank you all for spending all day long with me. And I'm done. I'm sick of sitting here. Appreciate each and every single one of you. Thank you for your time. It means a ton to me. Thank you for all the support and all the comments and stuff. Sorry I couldn't get to all of them. It's just a little overwhelming. But till we see each other again, guys and gals, please be safe, stay vigilant, carry a gun to keep you, your friends, your family, your community safe. And nobody is telling me what I need to do with my body. And I said that on a live. And if YouTube don't like that, TFB, too friggin' bad. Thank you, everybody. Hopefully I didn't miss too many of y'all. I'll see you on the next one. Take care of y'all. Take care of yourselves. Take care of each other.